And so the court is hearing that particular application this morning. We'll be joining the feed and take you to the Supreme Court shortly. I'll kickstart with you, Hansen, and then so that you can give us an idea of how these processes work within the courts.
So what we need to understand is that there are three sets of legs to the issue, all related. The first leg was the majority leader, Alexander Bagbin, invoking the original jurisdiction of the Supreme Court to interpret Article 97(1) of the Constitution to mean that the actions taken by these three MPs, actually, their application was centered on three NPP MPs and not the other one NDC MP. But essentially,
so this will be Gomoa West, Aguna West, Cynthia Morrison, Fomena, Isaac Esiama, and then Sum Kodjo Asante.
Yes. Right. But in all, what essentially it means is that these four MPs who are deemed to have crossed carpet, he wants the Supreme Court to interpret the Constitution to say that their actions do not necessarily mean that they vacated their seats. And he served the processes on the court. The standard practice is that when processes are served on you, you are one way or the other on the speaker. Right. The idea is that when processes are served on you, the understanding is that you let the status quo remain until the proceedings have ended. And so a typical example is the anti-LGBTQ case, in which case when the processes were filed, the president indicated that it cannot take the document and that bill has stayed in Parliament for all this while. So that's one leg of it. And then the Speaker of Parliament, who thought that he had not been properly served, went ahead to deliver his ruling. Then the second leg of the issue came up, which is Bagbin on Friday that's October 18, going to the Supreme Court, asking for the Supreme Court to stay the execution of the ruling of the Speaker of Parliament, which essentially would have meant that those seats would have been vacant and would have changed the power structure in the judiciary. The third leg of the case, as we have it now, is lawyers of the Speaker of Parliament going to the Supreme Court, telling the Supreme Court that one had no jurisdiction whatsoever to have heard that application in the first place, because in their view it is an affront on the supremacy or independence of the Parliament of Ghana. The second point they say is that that ruling by the service, so they want the stay of execution set aside. One of the grounds they are seeking to get the stay of the execution set aside is that the purported service of the application for interpretation of the Constitution, that service was done in contravention with Article 117 of the 1992 Constitution. Article 117 of the 1992 Constitution basically immunes the Speaker, members of Parliament, and the Clerk of Parliament from being served with court processes while the person is doing parliamentary business, is on his way to do parliamentary business, or is coming back from doing parliamentary business. The issue over the years has been, at what point do you determine if somebody is indeed doing parliamentary business? This brought up a circular which the Speaker of Parliament have alluded to, that the Chief Justice herself brought out to the Speaker of Parliament, which in a nutshell said service to these category of persons should be done only on Monday and should be done at the Speaker's office. This particular service was done on Wednesday, and the Speaker is basically saying that by not doing it on Monday, you have infringed upon Article 117 and also infringed upon your own circular, and you had no basis whatsoever to have given that directive or to have even heard the application in the first place. And so the lawyers of the Speaker, led by Thaddeus Sori, is making the argument before the bench of five, including the Chief Justice Gertrude Isaba Tokonu to see that they may rescind their decision and allow for the Speaker's ruling to stand.
In fact, the Speaker in his application says the court misapplied the law because his ruling was a non-judicial one.
Yes.
Kindly help us understand what he means when
the
matters are put in this context.
To also add to what Hansen said,
Right.
there was one point where one of the reasons the Speaker raised in his application was the issue of the principle of natural justice,
Right.
where they believe that the particular case and the ruling of the Supreme Court came as an ex parte,
Right.
and they believe that in that particular situation, the Speaker should have been given an hearing, and they didn't also believe that the decision to hear the case ex parte was really necessary because there were no exceptional reasons for hearing the case ex parte. So it's one of the arguments by the lawyers of the Speaker in getting the Supreme Court to overturn the decision. Now to your
Yes.
issue of whether the Speaker was rightly served. Whether the Speaker was rightly served.
And then, of course, the case he makes that the courts may not necessarily have power over a non-judicial body like Parliament.
Yes, the Speaker has always maintained that Parliament is a master of his own rules. According to the Speaker, what he did belongs to the rules, came under the rules of Parliament. And that the courts cannot come on sidestep or overturn how rules and regulations are done in Parliament. The Speaker also believes that Parliament is a master of its own rules. The Parliament is a very independent body. So decisions taken by the Speaker should not be interfered with by any other body, whether the judiciary or the executive. But this particular position of the Speaker has also been challenged by a number of lawyers and legal analysts who believe that the Supreme Court in this particular matter had every right to interfere and listen and take a look at what the Speaker had done. Basically because it was a constitutional matter, it was a matter which was with regards to the Constitution and the interpretation of the Constitution. Don't forget that the majority leader, Afenyo Makin, went to the Supreme Court for an interpretation of certain articles. Based on these same articles, the Supreme Court, the Speaker of Parliament made a ruling. And it's simple about how a vacation should be done, who has the power to order for the vacation to be done, who has the power to say you have vacated or you have not vacated. This is what the majority leader went to court to seek the court to give an interpretation to the Constitution and articles of the Constitution with regards to the vacation of seats. So it is the strong belief of certain legal persons that the Supreme Court has the power to interpret, and what the Supreme Court did was just to interpret the law or find a way of interpreting the law. But before interpreting the law, is asking the Speaker to hold on. So the Supreme Court hasn't gone beyond its powers. This is something the Speaker is challenging. The Speaker believes that the Supreme Court has gone beyond its powers. Therefore, it should relook at its decision and overturn its own decision today.
Well, the Speaker makes the argument that the power to stay execution of rulings, as bestowed on the court by the Constitution, has to do with the court's own rulings and that of lower courts under the apex court.
Yes, that's the school of thought which the Speaker believes in, that the Supreme Court can only stay decisions of the court.
And not necessarily
different bodies outside the court. That's basically the Speaker's argument, that his ruling, or he doesn't believe or work under the court system. His ruling is not a court ruling or a court judgment where the court or a higher court can't stay. It is the belief of the Speaker that, look, the Supreme Court or any higher court can stay the decision of a lower court.
Yeah.
and he, as a parliament, or the parliament as an institution, does not fall under the court system or the judicial system.
Yeah.
So it is not lower to the judiciary
Court
or the Supreme Court.
Yeah. Right.
So then the Supreme Court cannot come and interfere and stay, because basically Parliament is an independent body, is an arm of its own, is equal to the Supreme Court. I mean, it's equal to the judiciary in terms of governance.
Right.
That's the challenge of the Speaker, and that's the challenge of his lawyers, and that's what they are arguing out in court this morning.
Very well. Hansen, on the matter of natural justice, as is being argued out by the Speaker and demanding a fair hearing as well, I'm wondering how does one determine, or who determines the urgency of a matter, for which reason it will be filed as an ex parte motion or otherwise?
Well, it is left to the discretion of an applicant who is going to court, and so you may decide to go ex parte, that is, you're going before the judge to plead your case because of the exigencies of the matter. You cannot put the other party on notice. And mind you, the decision of the Speaker was taken in somewhere Thursday, by close of day Thursday. And so the team from the NPP side felt that the most important thing they ought to have done was to have gone to the Supreme Court to seek this application. And if they were supposed to go on notice, what it meant was that they would have filed, then the registrar of the court would have served the Speaker of Parliament. The Speaker of Parliament would have been given time to respond to the application, and then a date will be set for hearing or for judgment of the application. That could take a week, that could take 2 weeks. And so in their wisdom, they thought that the best thing that they ought to have done, particularly when they believe that the Speaker was taking an action against the Constitution, and to touch on the issues the Speaker have raised. It's brought up the conversation again that Ghana essentially runs a constitutional supremacy.
Yeah.
Unlike the United Kingdom, where there's parliamentary supremacy. And so in the United Kingdom, Parliament cannot be wrong. If Parliament does something that is wrong, it is Parliament that has to make a determination that indeed the action they took is wrong. But in our case law and practice have come to a conclusion that indeed we practice constitutional supremacy. So whereas Parliament has the right, and Parliament has the independence, and has been established that what happens in Parliament is a closed book. The Supreme Court have found a thin line to say that provided what you do in Parliament is in line with the Constitution, then we cannot question the political angle to what you've done.
Right.
But if what Parliament has done raises questions of being an affront to the Constitution, then it presupposes that the Supreme Court, which has been given that power by the Constitution, can't step in. And so what are the issues that we are talking here? The NPP side is saying that the sort of understanding the Speaker of Parliament gave to Article 97 of the 1992 Constitution is far from that. We've seen the response from the Attorney General's office, which have also argued essentially to say that the reasoning the Speaker gave to Article 97 of the 1992 Constitution is wrong in itself.
Right.
And that if you're saying somebody has crossed carpet, it should be the person's actions in relating to the current Parliament that he's a member of. So if an NDC or an NPP MP wakes up today and say that from now onwards I'm doing business with the NPP side in Parliament, then you can say it is cross-carpeting.
Right.
But if an NPP MP says in the coming 9th Parliament, I intend to contest on the ticket of the NDC, which he has not even won yet, which you don't know if the electors themselves
will vote for him.
Otherwise, he would now be doing business with the NDC in the 9th Parliament. That is a future Parliament. The Attorney General is saying that you cannot take that to be a cross carpet. Right. The Speaker's point is that if you take that interpretation, then what you're essentially doing is that you are weakening the hold of political parties in Parliament. Because then somebody can come to Parliament on the ticket of a party, and when the party sanctions him, he may now decide that in the next election he's going to contest with the NDC, assuming he came to power from the NPP, right? And then the party doesn't have any hold with him, and he continues to be a member of the caucus. What level of trust will even be between them? Would they get that sort of harmony to be able to work? And so he's thinking that for a pragmatic way of building our democracy and looking at our constitution, he sees it in that manner. Right?
So the Speaker's argument is more on entrenching the powers of the political parties in the House.
In the House.
And then the AG is more of the currency of Article 97. So the AG, and whether it is futuristic in nature.
Yes, so the AG's point that it shouldn't be futuristic. But the point here again is that, so this is what the Speaker is saying. This is what the Attorney General is saying. This is what the NPP is saying, right? And people are saying that the Speaker, by deciding to make a pronouncement, and if you read portions of his statement or ruling, depending on how you want to put it, you get the sense that he says he's looking at the spirit of the Constitution, right? And he's looking at the meaning of Article 97. And what those who have issues with what he's done is that immediately you begin to do that, then you're interpreting the Constitution. And in Article 130 of the 1992 Constitution.
Hansen, we'll come back to you, but let's go straight to the Supreme Court and let's join the hearing proceedings in the Supreme Court.
And Thompson Ajiabe. Ajiabe spelled Adjiaber.
Yes. Lords, respectfully, Kwekuedumeta for the respondent. My Lords, I appear with Abdul Hakim Alaja Suleimana. Yes. Lords, respectfully, Kwekuedumeta for the respondent. My Lords, I appear with Abdul Hakim Alaja Suleimana. Yes. Yes, Counsel, listen.
Your Lordships, respectfully, we have before you this morning a motion, a notice for review of a judgment of the ordinary bench dated 17th April 2024 under Article 1331 of the Constitution 1992 and Rule 54A of the Supreme Court.
You want me to write, don't you? You want me to write?
Yes, my Lord, I am sorry.
Brought under Article
And Article 1331 of the Constitution 1992.
Yes.
And Rule 54A of CI 16.
Yes.
Your Lordship, respectfully, we beg to move in terms of a motion paper, the supporting affidavit, and the exhibit attached. Your Lordship will rely entirely on a statement of case filed on even date 17th May 2024.
Filed
on the 17th of May 2024.
Yes. Is there anything that you want to add?
Yes, Your Lordship, if I may kindly address the court on a few points.
A few points?
Yes, a few points, Your Lordship.
Okay, yes, good.
Your Lordship, respectfully, this review application is brought on the strength of Rule 54A of CI 16,
Please.
where we are stating clearly that
You said that. You said that already.
where we are stating clearly that the exceptional circumstances which has led to a miscarriage of justice, which warrants the review of the ordinary bench's decision dated 17.
What are the exceptional circumstances?
Yes. Your Lordship, the nature of exceptional circumstance is that this honorable court, in delivering its decision, refused or neglected to pronounce and determine a specific grounds of appeal, grounds III, and the failure to pronounce on that respectfully of the appeal constitutes exceptional circumstances. Your Lordship, the authority will take guidance and that is where the court had overlooked very material and practically decisive matters.
Counsel, I thought you said you rely entirely on your statement of case.
Yeah.
And this is, what you are saying is very well articulated in your statement of case.
Yes, my lord.
So why are you rehashing your statement of case?
Respectfully, your lordship, no. I'm laying the foundation to tease out a very important point before this court.
Tease away.
Yes, my lord. Your lordship, the point is that the specific ground of appeal which is in contention Justice, I apologize just a second. Your Lordship, the specific ground in contention is this, that the Court of Appeal erred in holding that the second defendant was liable in negligence for the injury caused to the plaintiff when the second defendant had no responsibility over the dogs and was not owner or keeper of the dogs. Your Lordship, respectfully, if you go through the entirety of the judgment of this court, through the lines and the pages and the paragraphs, nowhere did this honorable court pronounce on this particular ground. This particular ground was formulated to bring out two critical issues, which seem to have been glossed over by the trial court and the Court of Appeal, and unfortunately this honorable court, I say that respectfully. And that is the fact that in delivering its judgment, this honorable court states as a fact that the first defendant is the owner of the dogs that caused the injury.
Very well, you're welcome back from the Supreme Court. Now, we know that the case in hand, or the matter that is being discussed, that's the hearing of the application by the Speaker of Parliament to overturn the decision of the Apex Court to stay the execution of the Speaker's ruling regarding the vacancies in Parliament has been, of course, ongoing since morning. The panel on that particular matter has taken a break. I'll give my colleague Hansen an opportunity to run us through what has been said in court so far up until this particular break.
So the court today was expected to hear the Speaker's application for the Supreme Court to set aside its ruling, asking Parliament or the Speaker to stay implementation of his own ruling that the 4 MPs by their actions have vacated their seats.
Right.
But even before the lawyer for the speaker, that Thaddeus Sorry, could move his application, the Attorney General raised 2 objections to 2 paragraphs of the affidavit in support of the Speaker's motion. In view, one of the objections was with respect to grounds on the fact that the Chief Justice and the panel breached Article 117 of the 1992 Constitution and also breached a circular that was released by the Office of the Chief Justice on the timing of serving the Speaker, the particular application. Another was also on the grounds upon which the Chief Justice came to a conclusion, or the panel came to a conclusion in giving its ruling. The Attorney General argued that these paragraphs were scandalous in nature and that they offended the rules of court, and there was a need for the Supreme Court to strike them out, meaning that they need not be part of the application that will be moved by the Speaker of Parliament. And then Thaddeus Sorry, he rose up to oppose the objection by the Office of the Attorney General. But not only did he oppose that objection, he also objected to the presence of one of the justices on the bench, that is Justice N.S. Gewu. So the point the lawyer for the Speaker makes is that Justice N.S. Gewu is someone who in time past had contested on the ticket of the NPP for a parliamentary election. And so he's essentially saying that this is somebody you cannot expect to be objective in handling a case which is political in its own self. And so he's objecting to his presence on the panel.
Just a quick one to that. Thaddeus Sorry is objecting to the presence of just one judge, Justice N.S. Gewu. But on the panel this morning, we had the CJ, that is Gertrude Tokonu. We had Mariama Owusu, Samuel Asiedu, N.S. Gewu, whose presence is being objected to by Thaddeus Sorry, and then Yaudakun Asari. These are the judges on the panel.
These are the 5 judges, on the panel today. And he's objecting to N.S. Gewu because N.S. Gewu, Justice N.S. Gewu, his lordship, he says has in previous time contested on the ticket of the NPP for a parliamentary seat. It came up during his vetting to the Supreme Court, and so he's impugning some form of bias on him. And
Right.
so the Supreme Court at the moment, the 5 judges, they have retired into chamber to consider these 2 preliminary objections. First is the Attorney General's objection to 2 paragraphs of the Speaker's application. And second is the objection to the person of Ernest Gewu, his lordship, as a member of the bench.
Right, Fred, I mean, your take on this. We know that some of these legal antics are always employed by lawyers in court, these objections and other, but the AG's objections that he has raised, that basically having to do with the language in these 2 paragraphs he's identified in the Speaker's application.
I think that what the AG basically is trying to say is that, look, some of the things you've said in that particular paragraphs are very scandalous to the Chief Justice.
Right.
Making it known in your paragraph that the Chief Justice is aware of an illegality. Once you're aware of an illegality and you grant
As in
that
just
so-called-
superintending an
superintending
illegality, right?
That's the AG's problem. The words and language used
Exactly.
in the application, and I think that's the challenge of the AG. On the issue of the justice who is being challenged, I think that is not surprising. From the very beginning, when he was appointed to the Supreme Court or nominated to the Supreme Court by the president, you would realize that the minority raised concerns over his party or political leanings. Justice Gewu has, like Hansen said, has been a parliamentary candidate on the ticket of the MPP some time back, before fully going into the judiciary to become a judge and rising to become a Supreme Court judge. And it's one concern that most minority members, especially on the day of vetting, raised concerns. I recall that the Member of Parliament for Buedi asked the question about
that would be Samson
Ahi.
Yeah.
During the vetting, asked the question about his neutrality, what his neutrality would be when it comes to issues which have to do with politics. And he assured that he was no longer a member of the MPP and he was going to live and work by the law.
Right.
It's no surprise that this matter has come back again, because you see, Nana, regardless of the fact that this matter is purely legal, there are a lot of political leanings in this particular issue. Political leanings as to who it benefits, who suffers, how it would go on to affect an election coming in December. So, hearing the objection by Thaddeus Sori, representing the Speaker of Parliament. And don't forget, the Speaker of Parliament is not just the Speaker of Parliament. He is a politician.
Yeah.
He had been a Member of Parliament on the ticket for the NDC for so many years. This issue, whether we like it or not, is an NDC MPP matter.
Yeah.
So when you see lawyers raising concerns over the neutrality of one person on the panel who is supposed to listen and hear and pass judgment on the case, which has to do with law, but underpinning it is the politics.
Yeah.
They have the challenge, of his neutrality. They don't believe that this justice of the Supreme Court may put aside his political leanings before and rule in a fair manner. This is what the court is saying. And you see, this has happened in the court so many times, where applicants and respondents have raised objections to judges sitting or hearing the case based on their relationship and affiliation to the case in so many ways. I recall during the Opuni case, which is still ongoing, the old judge, Onyenuga, there were so many objections raised about him, and even went all the way to the Supreme Court to get him removed from hearing the case. Even at the Supreme Court level, there's been a number of times where people, interested parties in cases, have raised challenges to certain members.
Remember in the election petition case, there was a similar matter for one of the justices at the time to recuse himself.
So, no, it's the current Chief Justice.
The current Chief Justice.
The current Chief Justice was asked to recuse herself from the case based on relationship and certain things she had been involved in the past.
Right.
The Supreme Court dismissed that application. So it's not new. It's not new happening in the court. But why it's also not surprising is because this is a legal case, but it's also heavily underpinned with politics.
Yeah.
So I'm not surprised and shocked that the people or the speaker and his lawyers are requesting and demanding the removal of that particular judge.
It is important to also point out that in 2020, when Justice Gewu was vetted, and something that he asked him that question, at the time he had indicated that he had resigned from the NPP when he decided to go into full-time judicial work.
Yeah.
And so he, at this point, if we are to take anything that he said at the vetting, then what he wants Ghanaians to believe, and I'm sure the point he may be pushing while the bench is considering the matter is that he's no longer a member of the NPP, that even though in time past he was a member of the NPP, he has tendered in his resignation. As to whether that will be enough for the other 4 judges to come to a conclusion that indeed his previous activities with the NPP will not cloud his judgment. The other issue also is that they did cloud his judgment really when he was empaneled for that October 18 ruling. Mind you, that was a unanimous decision, and so all the other 4 judges thought that the bench should go this way. Right. It was not only Justice N.S. Gewu who thought
that's the reason why
it should go
they are
this
raising
way.
the issue of natural justice, because I'm sure that if they were served on notice, they would have raised that concern.
I don't want to go into. Fair enough.
No, I'm just saying that it may be part of the
reasons why
they have raised the concerns of natural justice.
It may be part of the concerns, but the point I'm pushing our mind to is that he's 1 out of 5. Right. All the remaining 4 also thought that way.
Right.
In that also their thinking was also in that light, and so. I'm only saying that these are some of the things that will be considered in coming to a conclusion as to whether the Supreme Court itself will ask His Lordship Justice N.S. Gewu to recuse himself from the matter, because then there's not only a matter of
the accusation
of he doing business with in time past being an NPP member, and as I've indicated in 2020. For which Parliament itself approved of his candidature. He said he had resigned from the NPP. And so it presupposes that between 2020 and 2024 now, he's not being a member of the NPP.
And one of the things judges will also look at is whether his actions as being a judge has been influenced in any way from his past.
Exactly.
Whether he's done anything which warrants the fact that he should be removed because he made or had behaved in a particular way. And there will be a
paper trail to this, and so it can be verified.
Which would call for such an action. But in the number of years I've covered the court, I've hardly seen the Supreme Court actually getting a judge to recuse themselves in a particular panel. What usually happens is that the judges would usually, on a personal level, decide that based on your concerns, I would decide that I'm not going to hear the case, would write to the Chief Justice for the Chief Justice to empanel somebody else. But you hardly, yes, it may have happened 1 or 2 times, but you hardly find judges actually, or a panel actually asking one of their own to recuse themselves. That hardly happens.
Right. So, I mean, these objections have been raised, and so the panel has gone into conclave now.
Yes.
What is expected to happen when they return?
So when they return, two things. Is either they throw away the objection of the speaker, the AG, and then they hear the case substantively, because then now Mr. Sorry will be asked to move the application.
Wait, just a quick one, just to understand the processes. So it's that because the objection was raised by the AG, Thaddeus Sorry, acting on behalf of the speaker, has not been able to move the motion yet.
Yes, so the motion has not been moved yet, because the motion includes the affidavit, which are basically averments that the speaker has made.
Right.
Now, these averments, part of it, the AG is saying that they are scandalous to the court because of the language with which it has been couched.
Right.
And so the court cannot accept such a language. And I mean, you know, the legal profession, decorum is one of the important elements.
Yeah.
And so it is until that objection is dealt with, then the motion can be moved.
Right.
And so if it is dealt with and those paragraphs are taken out, then the averments made by the speaker will be short of 2 paragraphs. If you remember in the 2020 election petition, in the affidavit that was filed by, the witness statement that was filed by Asiedu Nketia, the NPP side managed to get some portions of it taken out. And so that is what the AG essentially is trying to do.
Right.
Then there's the issue about the judge. Now, if the panel comes out and agrees that yes, His Lordship Justice Gewu, by in his previous life being a member of the NPP, should recuse himself, then that means that the court will now have to find a replacement for him. Today is Wednesday, usually a busy day at the Supreme Court, and so it may not be difficult getting a replacement at that moment. If the court disagrees with Thaddeus Sorry, then Justice Gewu would be part of the panel, and then the motion will be moved. Of course, since it's a ruling of the Supreme Court, the lawyer of the Speaker of Parliament, Thaddeus Sorry, will have the right to ask for a review, a review of the court's decision, and that is absolutely his right. If he decides to exercise his right with respect to Mr. Justice Gewu, then that means that even if the Supreme Court comes out with its decision and it goes in against his plea, then the motion may not be moved today, because then he wants to go the other layer. Fred was alluding to the administrative process, but I mean the speaker, the Chief Justice, is part of the panel already, and so it's if you don't succeed in a judicial manner, I don't know how you may succeed administratively if you decide now to petition her office as the administrative officer of the judiciary to let a judge she was sitting with
recuse himself.
A judge here in panel.
A judge here in panel. A judge, after you made the plea in court, she agreed, she decided that no, that your plea is not right and that person should still be on the panel. So I'm only saying that when the judges come out, their decision can go 2 ways. Either to ask Justice Gewu to recuse himself, or they ask him to stay. I'm saying if they ask him to stay, per the processes, the lawyers of the Speaker have the option of going the judicial level of asking the Supreme Court to review its case. If they don't do that, then what it means is that the decision the Supreme Court will come out with will now inform the House to move the main application, which is an application asking the Supreme Court to overturn its previous ruling that asks the Speaker of Parliament not to implement his own ruling, asking for or indicating that 4 MPs had vacated their seats.
Right. Hansen has given us a nice explanation to what is expected to happen. Fred, I just want you to touch on if the court should go ahead and accept or allow the objection by the AG to hold, then that means 2 paragraphs out of the Speaker's application will be struck out.
Yes.
What legally, or I mean, in the processes in court, what does this do to the application by the Speaker? Doesn't necessarily weaken it.
It would weaken it in the point. It would weaken it in the point because those are 2 averments they've made, which they are using to back their call or request for the court to overturn the decision. So once you have those averments struck out of the court, it means that you are left with other averments you will be arguing. Probably you don't know. As I sit here, I can't tell what really they are standing on. If these 2 averments are their major standpoints, then there is an issue for the legal team of the Speaker. But we know that they made more than, it's about a 40-something paragraph averment they filed, about 49 or something, close to 50. So when the court takes 2 out, you still have 48 more to stand on to make your argument. Like Hansen said, this is a court process. They can always go back and challenge the decision of the court to strike out those 2 averments. And if it is the intent of the legal team of the Speaker to insist on their right, it means that we are going to see a very long period stretch of this issue. Because if they decide that they're going to ask for a review of the decision, it means that they would apply for it. The Supreme Court or this particular panel would need to hold on to their hearing for the review to be heard. For the review to be heard and be decided as to whether the old panel actually did the right thing or not. Otherwise, they can also continue with the other averments to argue their case. If, like Hansen explained, the other part of the objection, so there are 2 objections, one from the AG, one from the Speaker.
Acting on the orders of the Speaker.
One for the Speaker. So the first one has to do with the averments being struck out. Once the averments are struck out, the lawyers make a decision whether to carry on with their argument or...
So based on that, then they will have to file
the motion. Or they decide that, look, we have a challenge with the decision of the panel to strike out these 2 averments. So we are going to seek for a review of that decision. We are going to seek for a review of that decision. That review of that decision means that the panel would have to be reconstituted. Right now there are 5. So possibly 7 more, 2 more will be added to the current panel to make it 7, to review the decision of the 5 panel judges and justices who struck out, who may have struck out that particular.
But we don't know for
certain.
speak now,
the decision or the ruling on the objections haven't come out yet. So if it happens like that, Thaddeus Sori and his team have the decision to make whether to go ahead with the rest of the averments they have, or go back for a review to get those averments back into their...
Let's look at the objection by the Speaker's legal team, Thaddeus Sori, and the demand or request for Justice Gewu to either recuse himself from the panel or be moved from the panel. If it is upheld, I mean, then that's positive, of course, for the team. But if the court decides against it, what are the options for Thaddeus Sori?
He can go back for a review.
So there's always an avenue to take the case
to go and review the decision of the court.
So particularly for this one, there are 2 options. There's the judicial option of going for a review. And then there's the administrative option
of applying to the office,
writing to the Chief Justice to remove the judge from the case.
But
the point I've explained
if you lose
is
in
that
court with the CJ sitting,
so the CJ you made the point before in court is the same person you are applying to administratively.
It's the same person sitting on the matter, same person that empaneled the judge you want to be removed.
But I mean, to be fair, that's the job of the Chief Justice.
Exactly.
And if the Chief Justice empanels a judge, and it so happens that that judge engages in actions or has engaged in actions in the past that may affect that judge's ability to impartially deal with the matter. In time past, we've had Chief Justices deal with that matter accordingly. And so that may not be a hurdle. But the options for the Speaker's team, after listening to the panel, if it doesn't go their way, they have the option of invoking the review jurisdiction of the Supreme Court. And so, mind you, the Supreme Court is the only court that has the power to look at its own ruling again for a second time. And that will usually end the matter. So if you go the review stage, you are done with that case. And so, and again, I'll go back to the 2020 election because it's one that was televised and a lot of people got to hear watch the proceedings and got a lot of understanding with the court processes. Before, mind you, when Chachuchi Kata sent almost all his applications that he sent, all of them were declined by the Supreme Court. And for almost all of them, he went back for a review. And so that's what we're talking about. So the lawyers of the Speaker of Parliament, if the ruling does not go in their way, they have the option of going for a review. But I'm saying that particularly for a point to get a judge out of a case, you can also go the administrative way of asking the Chief Justice to look at the matter and then take a decision. But we would only leave it at that level for the panel to return and come back with their ruling. But these matters are important to happenings in Parliament because it is out of this that has necessitated the adjourning of the House for what you call for an indefinite period. And so depending on what they and mind you, the majority in Parliament, or Alexander Penyumakin and his side, they've triggered processes to recall the House. This is a must process. This is not a process that the Speaker has an option. The wording there is shall. So immediately those people have signed and the Speaker has received their petition, he needs to take steps to recall Parliament within a certain set of days. Now, are they coming back to Parliament with the same problem? Because the Speaker didn't necessarily pronounce on the Supreme Court ruling at the last sitting. But by this application, we now get the understanding that the Supreme Court the Speaker disagrees with the Supreme Court. So if we are able to get a ruling of the substantive case today, it to a large extent goes to settle the matter when the House reconvenes. Because a lot of people have been saying that the Supreme Court should insist on parliamentary independence and ignore the ruling from the court. But
the Speaker
should have insisted on parliamentary independence and ignored on the ruling to stay of the Supreme Court to stay his action. But he was called upon by some persons to say that that is not a democratic way to go. The best way is that if the court makes a pronouncement, as long as that pronouncement has not been overturned by the same court or another court of competent jurisdiction, that pronouncement is right. And so even though we understand that the Speaker disagrees with the Supreme Court, we also get from his actions that he's not going to unilaterally say he's not going to agree with or going to go according to what the Supreme Court is saying. but he's gone to them for them to overturn their action. And so if we get a ruling and the Supreme Court say overturns its action, then what it means is that when Parliament is recalled, we'll have NDC 136, we'll have NPP 135 until the substantive matter is said. But if the Supreme Court decides to go in line with its ruling and insist that it was right to have stayed the action of the Speaker, then that means that we'll come back to Parliament with 137 NPP, 137 NDC, and one independent who has been doing business with the NPP, which is 139. And that means that Parliament will reconvene with 139 people, 138 MPs on the side of the majority, which is for the NPP, 137 on the side of the minority, which is NDC. So how proceedings will go today is very important for the impending sitting of Parliament on the day that is yet to be set by the Speaker of Parliament.
Speaker. Indeed, and I agree with you entirely on this. The panel sitting on this particular matter have two major tasks to do in conclave now, and that will have to do with the objections raised by the AG and that of the Speaker's lawyers. When they come out, it is expected that they give us a ruling on what decision they have taken on these two issues. But then there's the actual matter of the application by the Speaker to have the decision of the Supreme Court staying the execution of the Speaker's ruling on the matter of vacancies in Parliament. On the other hand, there's also the Afenyo-Markin case that is also yet to be heard.
So that's the case which all these things stand on.
From.
That's the case to interpret Article 97 of the Constitution, which deals with the vacation or the processes or the determination on what it means for you to vacate
your seat
in
Parliament.
So that is the actual case which all these other cases have found their roots from. So Afenyo-Markin's case is still there. What now we are dealing with are the other issues which have arisen from those cases. Like you said initially, the first matter the court had to address was the writ by Afenyo-Markin seeking the interpretation and also seeking to stop the Speaker from making a determination on the vacancy of those seats, which he did. The Speaker went ahead to make that ruling.
Which they have also argued that the Speaker is in contempt of the law, knowing that there's such a pending case.
Exactly, because of the injunction application. But you see, with injunction applications, there are always two schools of thoughts. The first school of thoughts being that the moment you are served with an injunction application, it's as good as you being injuncted till the court hears the matter. There's the second school of thought which believes that, look, the application is just an application. So once you have been served, you can still go ahead with whatever you are doing till the court determines to injunt or not to injunt. So the Speaker did not even go, that day he didn't even go through the issues of the injunction or not. He went and gave a ruling. Out of that ruling came the application for stay. Out of the application for stay, which the Supreme Court upheld, has come the Speaker now asking for an overturning of the decision to stay. And out of the application for the decision to stay has come the preliminary objections of the removal of Justice Jehu and the striking out of two paragraphs of the amendments by the Speaker.
Right. I mean, it's important that we chronicle the issue so that there's a clear understanding of how we got here. So, thank you for that. We'll be joining the feed soon. We are getting indication that the judges are returning to announce their decision or to give a ruling on this particular matter, which will have to do with the objections raised, one by the Attorney General regarding 2 paragraphs of the Speaker's application, and of course the objection raised by lawyers for the Speaker to have Justice Gewu removed from the panel. Let's take you to the Supreme Court and hear what decisions have been made.
Within the ranks of the Superior Court is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention. It should be well understood that when Parliament approves a qualified citizen to be a Justice of the Superior Court, pursuant to Article 1284, the representatives of this country have appreciated the ability of that qualified person to contribute to justice delivery in the country. Second, the subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived. Move your application and dismiss.
We have before the court an application praying the court for an order vacating.
So sorry, can you do it in 10 minutes?
Very well, I'll try to do it. The order of the court dated the 18th of October 2024 and setting aside the processes and proceedings in the court leading to the order. We have set out the grounds on the face of the motion paper. There are 8 of them. Now deal with the first ground. The first ground is that the writs or the processes on the basis of which the court's jurisdiction was invoked for the order are void because they were filed in violation of the rules of the court. The rules of the court are within the cognizance of the court, so I will not belabor them. But it's important to state right from the outset that they concede the fact that the processes were filed contrary to the rules of the court. But all they are saying in the affidavit of opposition is that the court is capable of carrying, not by reference to Rule 79 of the rules of the court, but Order 81 of the High Court rules. My Lord, we are saying that that irregularity is incurable, and this court has re-emphasized that in very recent cases in this court. My Lord, I refer just to 2 cases. The case of Mahama Yarga, an Attorney General, writ number 1, J/13/2022, dated 29th March 2022. There's also the case of Ken Kranchi versus Attorney General, writ number J1/16/2023, 14th November 2023. All these were writs which invoked the original jurisdiction of the court to interpret the Constitution. This court held that a violation of the rules nullified the proceedings. We also want to emphasize that by the decision of this court in the case of National Investment Bank number 1 versus Standard Offshore Trust Company number 1, reported in the 2017 Supreme Court of Ghana Law Report at page 707, the court held that where the provisions in the rules of court use the word shall, it is mandatory and should be enforced. We urge the court to follow these decisions. We should also add that where the irregularity complained about arises from originating proceedings, like in this particular matter, the court has also been consistent that such irregularities cannot be cured. So, several reasons why. In writs, recently the court has made the point nullifying the writs. Secondly, the rules are mandatory, and this same court says that when they are mandatory, they will be enforced. And finally, where the proceedings are originating in nature, there can be no waiver. There can be no waiver. But that's the recent position of the court. But we're saying also that even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked. Was not properly invoked because the court lacked jurisdiction to entertain the matter as a matter, the purpose of which is to determine whether or not the seat of a member of parliament is vacant. That matter belongs exclusively to the jurisdiction of the High Court. And this court has affirmed that consistently, not deviated in one, that if it has to do with the membership of a person in parliament, that belongs in the realm of the High Court, not this court. But I would want to emphasize the point that, admittedly, in every instance, there would be that the facts on the basis of which they are before this court arise. There will be a dispute between two people regarding whether or not the person properly is a member of parliament or not. And that has to be determined by reference to the constitutional provisions. It won't make it a dispute properly invoking the original jurisdiction of the court. What I'm saying is that wherever the question arises as to whether or not a person is properly a member of parliament, whether he ceases to be or his seat is vacant, there will be disputing positions, there will be differing positions. But the Constitution says it's the High Court that must determine that matter. And in this particular instance, the question is whether the parliamentarians who are the subject of the instant suit, their seats have become vacant. And the Constitution clarifies the position by telling the High Court the instances in which those seats will be deemed vacant. It's a cross-carpeting situation. So it's a matter of evidence for the High Court to go into and find out whether the facts establishing those circumstances in Article 97 have arisen or not. It's not a question of interpretation. The cases. Okay. But we're also saying that the court had no jurisdiction to stay execution of the ruling of the first defendant. And that one, 3 main points will deal with that. First of all, the substantive suit before the court never challenged the ruling of the Speaker. The suit before the court had nothing whatsoever to do with the ruling of the Speaker. Interlocutory reliefs made by any court of the land relates to the substantive dispute before the court. That dispute was never before the court. And so, once the dispute was not before the court didn't even have jurisdiction to make an interlocutory relief in respect of that ruling. Secondly, the High Court's ruling, the first defendant's ruling, is not a judicial decision which is properly the type of order or ruling which is the subject of the court's orders for stay of execution. At the very best, it's an administrative decision. It's not a judicial, it was not based on any judicial determination of any matter. Linked to that fact is the trite position that when we say stay of execution, we don't say it as a semantic expression, by way of semantics. It is based on the rules of the court. It's a statutory position that certain matters are liable to be progressed by way of what the law says, execution. And the law defines how to execute things, not from anywhere, but from the judgments of courts. The Speaker's ruling is not one of them.
The Speaker's ruling is not executable.
It's not executable within the meaning of the rules that govern the practice before this court and any other court for that matter. That's just the third ground. And the fourth ground, let me make reference to the cases, is that the processes, the processes initiated for purposes of the order, the ex parte application, was made in breach of the rules of natural justice. And this arises from a plain reading of the rules of the High Court, which provide for applications, because the rules in this court don't provide extensively for applications. My lords, I will refer to Order 19 of the rules of the High Court, which say clearly that every application must be made on notice. That's the first rule, which allows for ex parte applications. Our submission is that the rule 3 of 19 talks about ex parte applications, and it says subject to Rule 1, sub Rule 3. That's of Order 19. May be made ex parte where any of the rules provides. Circumstances, the court considers it proper to permit the application to be made. Now that's all. We should read the sub-rules in context. The court may make an order ex parte on such terms and subject to such undertakings as it considers just, where it is satisfied that the delay caused by proceeding in the ordinary way would or might entail irreparable damage or serious mischief. Now, my lord, we are dealing with a plaintiff who has demonstrated that he is capable of getting the court to sit at very short hours. He files his ex parte application at 12:40. He gets a panel of the court to sit at 2. Our submission is that he should have made it on notice, together with a motion for abridgment of time. There was an intervening Monday before Parliament would next sit, and the first defendant would at least have been given an opportunity on that presentation to the court on the grounds and basis for that application. And so that's the reason why we contend that the application itself did not properly come within the exception to the rule that he should have come on notice, because it was always possible, given the facts of this case. On the basis of that, we further contend that the order of the court was also made in breach of the rules of natural justice. Because when it came before the court, within an hour and a half or so after it was filed, the court could have directed that the first defendant be put on notice to be heard on the coming Monday, so that the facts will be properly put before the court to enable the court to reach a proper conclusion. We further submit also on another ground that the rules of courts and practice did not permit the type of order that was given by the court. bearing in mind the first rule again, as was espoused by the court in Barclays Bank and Ghana Cable, that ex parte, bear in mind the principles laid down by the court itself, that in the case of Barclays Bank and Ghana Cable, 1998-99 Supreme Court at page 1, that ex parte applications and orders that flow from them are anomalies in our system. And in that particular case, the court emphasized that no ex parte order should be given pending the final determination of the matter. But that is what the court did in this particular instance. In fact, it's contrary to the rules of practice and the established position of this court in Barclays Bank versus Ghana Cable. And we've also already made the point that since the ruling of the Speaker was not the matter that was before the court couldn't have made an interlocutory order on the basis of the suit that was before the court. There was nothing before the court. Now, we also note from the order that there was an application for stay of execution of the ruling of the court based on the writ that was filed before the court. And if my lords, the leave of the court, should take a look at the reliefs that were sought by the plaintiff, we realize that 3 members of parliament were listed.
Hold on.
Yes.
When the writ is examined,
it
mentions 3 members of parliament.
3 members of parliament. The first of which is Honorable Andrew Asiamwa Amuako, who is now going to contest from the position of an NPP parliamentary candidate, no, from the position of an independent to NPP parliamentary candidate. His situation will be covered by Article 97, 1H of the 1992 Constitution. The reliefs that I see do not mention Article 97, 1H of the Constitution in the first relief. So an issue of interpretation is not sought for in respect of that particular relief.
Submission.
Yes.
This is your view.
Yes. Then, my lords will also realize that the reliefs don't cover Honorable
I've been elected that you spent 16 minutes.
Oh, really? I'll be winding up, my lady. I'm sorry. They would realize that the reliefs cover the Honorable Peter Yao Kwachi Aka, the NDC MP. Do not cover him. The reliefs of the substantive rate do not cover him. But the application covered him, and the orders covered him. So, on that ground, we say, even the orders exceeded the scope of the application and the nature of the suit.
Hold on, the scope of the application or the scope of the relief?
The scope of the relief sought in the substantive
action.
Yes. And because it exceeded that, the application could not have been in respect of those the substantive suit. And as we finally submit that because this matter was brought ex parte, the balance of convenience was not properly employed by the court, which is a ground upon which the court made its decision, because of the fact that allegations were made about what was likely to happen in Parliament, and there was no foundation whatsoever for it. And so the court's jurisdiction wasn't properly invoked, especially in respect of Articles 1913, which requires a fair hearing, a constitutional right to be accorded to every person, and the provisions of 296A and B, which require the court to
exercise
discretion in a particular manner. So we pray that there was every opportunity, and the first general would want to be heard on that. And just before I sit down, the Hansard that was relied on, as already said, was not the official Hansard. Well, we pray accordingly. Not so. Not at all. But there are members of parliament, if they come in candor, get up and say it is official, it's fine. Yeah.
It is fine.
Agree with me.
Yes.
Lord, with respect, we are vehemently opposed to the application, and we rely
Mr.
on...
Bedu, you have to hurry up.
Very
You
well.
like to take your time.
Very well.
I always have to regulate Mr. Sorry because he tumbles his words out. But as for you, you pull them out. So now,
Lord,
don't pull them out like that.
Very well, I'll try and speed up. My Lord, with respect, we do so by relying on our affidavit in opposition filed.
May I find out whether Mr. Gatti has once again relinquished his privilege?
My Lord, no.
Because we will not allow you to argue half and leave half to Mr. Bedu. It will not happen.
I appreciate that.
So have you relinquished your...
argue this.
Thank you.
If subsequently there's another matter.
Thank you very much. Mr. Bedu, please continue. Your 10 minutes are running.
We oppose the application by relying on We oppose the application by relying on our affidavit in opposition filed on the 29th of October 2024, and we rely on all the depositions therein. Of notable concern to us is our paragraph 4, which is a counter to the contention by the first defendant applicant that the procedure adopted by us in commencing this action is questionable.
Is this the affidavit of John Bosman?
That is so, my Lord.
Go on.
Lord, in doing so, we wish to advert the mind of the court to rules 45 and 46 of CI 16. Which is a provision on procedure for invoking the original jurisdiction of the Supreme Court. The rule provides that any such invocation shall be commenced by a writ and not an originating motion. And we were accordingly guided. The rule further provides at Order 46 that it must be accompanied by a statement of case. Rule 46. We're talking about Rule 46 of CI 16.
Yes.
That it must be accompanied by a statement of case. And, my Lord, we accordingly complied. My Lord, our second objection regards the nature of the reliefs sought by the plaintiff. It has nothing to do with Article 99, Clause 1 of the 1992 Constitution. It was a plain and simple case of invocation of the original jurisdiction of this court for interpretation of Article 70, Article 97, Clause 1, G and H. And, my Lord, we have painstakingly stated this in paragraph 10 of our affidavit in opposition, as well as 11. My Lord, our third ground of opposition where we insist that the service of our writ and the motion or notice for interlocutory injunction on the Speaker of Parliament through the legal office of Parliament was good service. Despite the fact that it was left on the table of the officer who received the processes. This was a day before the ruling of the Speaker of Parliament. It was done on the 16th of October 2024. And the Speaker went ahead to deliver his ruling on the 17th of October 2024. So our humble contention is that at the material time incidental to the delivery of the ruling, the Speaker was fixed with knowledge of the pendency of the action before this Honorable Court. Yet he went ahead in this regard. My Lord, our fourth ground can be found at paragraphs 18 and 19 of our affidavit in opposition, where again we've taken the pain to state that the order of this Honorable Court on the 18th of October 2024 granting a stay of execution against the ruling of the Speaker of Parliament does not amount to any interference with the procedures and business of Parliament. My Lords, per Article 2, Clause 1 of the 1992 Constitution, an invocation of the exclusive original jurisdiction of this apex court is the right of every citizen of Ghana. More so when the applicant in this instance is the majority leader and the leader of the majority caucus in Parliament. He had an inherent interest in the said decision of the Speaker of Parliament, and for that matter, had every right, my Lord, to seek justice from this august forum.
But you know that under Article 2 actions, you don't even need to have an interest.
Exactly.
Your community of interest is with the Constitution of Ghana.
Exactly. So, my Lord, the point we seek to make
because this point that you are making, I don't think it adds anything to this.
Very well. So, my Lord, we say that guided by the Constitution, he need not show any interest. But even so, he had an interest. My Lord, this is further fortified by Article 132 of the 1992 Constitution, which vests this Honorable Court with authority, with supervisory jurisdiction over any adjudicating authority, in Ghana, regardless of being a separate arm of government. Lord, our faith ground is contained in paragraph 21 and 22 of our affidavit in opposition, giving our justification for resorting to an ex parte application. Paragraph 21 and 22 of our affidavit in opposition. My Lord, we have stated that we could anticipate potential irreparable damage and mischief if the order was allowed to stay. And this action was to commence in the ordinary way. My Lord, we fortified our submission by relying on Order 25 Rule 8 of CI 47. My Lord, the said Order 25 Rule 8 identifies of CI 47. Lord, a minute. My Lord, the point we seek to make is that, my Lord, 1-8, very well. Very well. My Lord, I'm grateful. 1-8, very well. My Lord,
and just for the record, read it. You don't have CI 47 there? Then kindly move on. We've helped you by telling you under 25 Rule 1-8, not 25-8. So you can move on. Please. Your time is up.
Very well. Lord, what we intend saying over there is that there was an element of urgency. There was an element of urgency associated with the application and the need for a dispatch response. Moreover, any mischief achieved by the ruling of the Speaker was irreparable, considering the fact that those 4 constituencies would have been bereft of representation in Parliament between now and its dissolution. My Lord, per Rule 5 of CI 16, This honorable court is the only court of the land seized with the power seized to prescribe rules of practice and procedure. So regardless of the fact that granting an ex parte application for limited number of days is not stated in the rules of the Supreme Court, my Lord, the court was all the same vested with the power to make the order it made, and nothing unprocedural could be raised in respect of the order of the court. More so, my Lord, Article 2, Clause 2 of the 1992 Constitution give this honorable court the power to make appropriate directions that it may consider appropriate for giving effect or enabling effect to a declaration. My Lord, we're saying that in so long as those affected members of parliament were not given the opportunity to state their side of the story before the speaker made his order, the rules of natural justice, the Audi Outram Partem, was breached. This was a statement made by a member on the floor of Parliament. This was a statement made
I think you're going too far.
Lord, I'm rounding off. This was a statement made by...
I think you're going too far.
Very well.
We can only limit ourselves to what is before us.
My Lord, the plaintiff is questioned.
You have responded to that.
Yes.
Very
well.
You said, if you don't mind, I can read what you said.
Very well.
I can read what you said. The invocation of the jurisdiction of this court is a constitutional right of any citizen.
Very well.
Pursuant to Article 2.
My Lord, in that circumstance, then I crave your indulgence to round off my argument.
So you are done?
Yes, I'm rounding.
Thank you.
That, my Lord, all said and done. All said and done. My Lord, all said and done.
There are many people here who are not here because of this case.
I know.
Their work needs to get done.
Lady, I'm sorry. All said and done. It is the standpoint of the plaintiff, respondent in this case, that he has not breached any procedure in seeking the order which is now being sought to be set aside. Neither is his action in breach of any substantive law or the Constitution governing the Republic, but granted without admission that there was even one. Rule 79 and Order 81. No, Rule 79 of CI 16 and Order 81 of CI 47. My Lord, makes him curable by this honorable court. Lord, I rest my case. I'm grateful. And my Lord, whether executable or not executable, an order of stay is made to operate. And Obrenu Kwisata versus Ghana Telecom is not far-fetched on this score.
They should be opposed to the application, rely strictly on points of law. They should, before I proceed, may I respectfully announce a reconstitution of our representation. It's been joined by the Deputy Attorney General, Dana Asunabadapa. So it's a full house. The Office of the Attorney General is properly constituted. We submit that the instant application is offensive to the rules of procedure of this honorable court, is unknown to the laws governing the jurisdiction of the court. The first point we make respectfully is that the Constitution has set out in clear terms the manner in which the decision of the court can be made. This application completely violates the laid down procedure for challenging a decision of the court in the Constitution. Article 133, clause 1. 133, clause 1 of the Constitution vests the Supreme Court with power to, and I quote, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Respectfully, the instant application seeks an order setting aside the process and proceedings of the court and vacating the order of the court. Respectfully, the decision in question, exercise of right. Respectfully, Article 133, clause 1, the review, 133, I'm sorry, 133, the review decision of the court. Respectfully, my contention is that this provision is a rule under which a person aggrieved by a decision of the court comes by to seek a review or variation of the decision. The instant application is not an application for review. It doesn't invoke the court's review powers and is therefore unknown to the laws governing the jurisdiction of the court. Especially Article 134 also vests the Supreme Court with the same powers of review of a decision of a single justice. Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed, varied, or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures. Especially, the second point we make is that the application mixes up grounds for a substantive defense to the action with matters that, in the view of the first defendant, constitutes a basis for a setting aside of the service. And this respectfully is wrong. The court will notice the motion paper. The grounds for the application are stated as, and I respectfully I'll quote, I'll just be quick about it. The writ by which the plaintiff has purportedly invoked the court's original jurisdiction is incompetent. The court has no jurisdiction to entertain the suit before the court. The court has no jurisdiction to stay execution of a ruling of the Speaker of the Parliament of Ghana. 12 to 18 of the affidavit in support also raise matters which constitute a substantive defense to the action. And I respectfully will quote paragraph 12. So the words used in Article 97, clause 1, paragraphs J and H of the Constitution are clear, unambiguous, and have no disputed meaning, and no basis exists in the processes filed for assuming that there's dispute. Then paragraph 13 is that the words used in the provisions of Article 97, clause 1, paragraphs J and H simply mean what they say. That is to say, when a member of Parliament leaves the party on the ticket of which they are elected to Parliament, to join a political party or to become an independent member of parliament, or where a member of parliament elected as an independent member of parliament joins a political party, they shall vacate their seat. Respectfully, I will turn over to paragraph 29 to 32 of the affidavit in support. And again, they constitute substantive defenses to the action.
Honorable Attorney General, you know you have 10 minutes.
Yes, please. My lady, I'm still well within the term. I'm sorry. So it says, paragraph 31. Further, the 19th Constitution of the Republic of Ghana provides for the well-known separation of powers doctrine, whereby the scope of the powers of each arm of government is set out, and no arm of government is expected to overstep its bounds. The same is repeated in other parts of the affidavit. So the point I make respectfully is that when a defendant takes the view that the writ does not invoke the decision of the court because in the view of the defendant, the words of the Constitution are clear. The rules do not permit the filing of an application to set aside the writ on that basis. Indeed, the grounds for such a contention will have to be in a statement of case filed at the point raised for determination by the court. And the court will notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General file issues for determination in this matter, and those are issues raised in for determination by the court. Respectfully, indeed, the application completely misunderstands and misconceives the Supreme Court's original decision. And I made the point that, indeed, the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, Counsel for Defense Defendant, in which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a statement of case in it, and totally, his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect of a provision of the Constitution than the instant case. But indeed, my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. That would be the basis for lawless conduct. And this honorable court owes a duty not to encourage him. I'm fortified in this proposition by the locus classicus on the matter to forward an Attorney General reported in 1980 Ghana Law Report at page 637. And where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the invocation of the court's original decision. So respectfully, the points I make today are not points being sought to be established today. They are matters that have been long established 40 years ago in this honorable court. I quote from page 650 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to Vacant. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon an interpretation of the Constitution. Once there's a controversy, a justiciable issue, we believe that under the wing of interpretation as contained in paragraph A of clause 1 of article 118, the court has jurisdiction to detain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectfully, the court went ahead to make the point that in a constitutional action, the community of interest is with the Constitution. There's even no such thing as a plaintiff and a defendant, and therefore the writ which mentioned some members of parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of parliament and have just stated a question for determination by the court, whether upon a true and proper interpretation of Article 97, Clause 1, paragraphs J and H of the Constitution, a seat of a member of parliament becomes vacant upon the occurrence of A and B. And that is it. And the court would have been seized with the jurisdiction. My lady, the first defendant makes reference to an alleged denial of the right to a hearing on the entire pattern by the filing of a motion ex parte. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court entertaining an application for application ex parte. If indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court. Respectfully, I would respond to the contention made by my learned friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I do not seek to even go into the merits of the understanding. But the point must be made that constitutionally.
No, hold on, please.
Right.
I think that for the benefit of the public
right.
of this nation,
right,
it is important to address the facts behind that matter.
Right.
SBB did. Because there had been a circular in 2021 to regulate service on members of parliament. And indeed, the Speaker of Parliament invited me as Chief Justice to discuss the return to that regulation. So I reviewed what my predecessor did, and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Lady, in addressing the legal import of that circular, I would note respectfully that I'm just looking for a circular, that what is paramount before the court in an action of this nature is the proper interpretation of the Constitution. And indeed, as held in before an attorney general, even if, assuming it had written, even if the CG had written such a letter, for me, with all respect, it's immaterial.
A circular.
The circular, written such a circular, it is immaterial for me. It is a construction of the words of the Constitution that matter. Before an attorney general even indicated that the Chief Justice, who had lent himself to the process, which was subsequently pronounced upon as unconstitutional by the court, could not have waived any right whatsoever. Because there's no such thing as estoppel under the Constitution. And indeed, I look at the provisions, the words in Articles 117 and 118. All it says is that civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of the Clerk of Parliament while he is on his way to attending at or returning from any proceedings of Parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Attorney General, can, or any citizen of the land, having in both the of the Supreme Court, can serve the process on a member of Parliament, the Speaker of Parliament, or a clerk to Parliament, except when he's on his way to Parliament or returning from Parliament. That is what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana.
I know I have a right to reply, but it's done over 25 minutes. Yeah. Let me, we've been checking.
Attorney General, you have 1 minute left.
But I know I have a right to reply, especially that he got up only on points of law. So but he's exceeding.
Please sit down.
Yes, the point of law I made it because the application.
Please don't waste your 1 minute.
Madam Friend, the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to the Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court in Tufo and Attorney General and further fortified by J.H. Mensah and Attorney General reported in 1996 Supreme Court of Ghana Law Report stated clearly that in Ghana there's even no such thing as a political question. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for First Defendants, that it was an administrative decision of the Speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I respectfully submit that the application before you is totally offensive to all rules and procedure of this honorable court, is unknown to the laws of Ghana, and must be dismissed. I pray accordingly.
Just some short points of law, especially that they were made on points of law, and I'll be very short. First point, that the application is unknown to any rule or procedure and offensive and all of that. First, the simple answer. Since the days of Mosi and Bajina, elementary, first rule in the civil procedure class is that if an order is a nullity, you can come by any procedure to set it aside. It remains the law following from, he likes to cite cases of vintage. He says over 40 years. You calculate when Mosi and Bajina was decided, 1963.
Mr. Sorry, all your juniors are here.
They were here when they said there is a misconception and a misunderstanding. They have remained here. And this is the clearest example of a misconception and misunderstanding. I said from 1963 up to 2000, and we are now in 2020 something. It remains the law, elementary first rule. 2, that I'm challenging the jurisdiction of the courts, and I'm saying, with all due respect, some matters don't fall within the jurisdiction.
Some matters do not.
That this matter doesn't fall within the jurisdiction of the court, and that I'm mixing matters that should go to the defense and then an objection.
Now, the point made
yes.
is that if you are urging that the writ is incompetent,
yes.
that should be separated
yes.
from submitting a defense to the substantive action.
Okay.
That's one.
Yes.
Second, that if this court gives an order and you wish for it to be vacated, reversed, varied, discharged, the onus is on you to bring an application under the review jurisdiction of the court, and not an application such as you have crafted.
Yes, madam.
That's the point.
And I'm saying that the tried principle of civil procedure is that the rules of review aside, this court delivers judgment according to three main yardsticks: statute law, common law, and the well-known practice of the courts. That has been consistent. And the well-known practice of the court and the common law is that you come and set it aside. And I'm saying way back from everything up to date, that remains the law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court, there are two ways and several ways, elementary civil procedure. I can take it in limine or put it in my defense. And I'm taking it in limine. Another elementary point. Now, let me just deal with the Article 2.1 point thunderously said, in all of the cases involving Article 99, the jurisdiction of the court to determine a membership of Parliament, they also come under Article 2.1. But the court has always said that yes, if they didn't invoke Article 2.1, they wouldn't have been here. But the court has said, look, we will keep our streams clear. Then you cite to for an Attorney General and about the fact that if a matter is within...
Your 1 minute is up.
Well, there are other cases. More recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And as for the circular, my Lord the Chief Justice must have had reason to issue it, and the Speaker must have had reason to respect it.
And it has constitutional power.
If it's not constitutional, he knows what to do. He should come and declare it unconstitutional. But otherwise, then the Speaker should feel deceived by it. That is the point.
You are done.
I'm done. But if my time was up anyway.
The case is stood down for the court to rule.
All rise. Benjamin, please tell them to switch it off. Tell them to switch it off. Please now, hurry up. They should switch it off because why are you filming whilst we are going to do another thing? Oh, he could have.
This is Channel 1 Television. You're welcome back from the Supreme Court, which is hearing that application filed by the Speaker of Parliament, Bagbin, to have the court overturn its decision that is staying the Speaker's ruling concerning the 4 vacancies in the House. We'll take a quick break. When we come back, we'll engage in a conversation surrounding all the arguments as presented by the three lawyers before the Supreme Court today. This is Channel One TV. Stay with us. We'll be right back.
Facility Pro Management Services Limited, the most
Complete this rhyme. Twinkle, twinkle, little star.
How are you working? How?
Who's that?
Welcome to The Point of View.
Welcome to Face to Face on Channel One Television.
And hello, welcome to What the Papers Are Saying.
This be football made in Ghana. It be the only pidgin show where it day on your screen. Channel One TV.
Thank you so much.
Some people are late. You know, they have to catch up. City TV is now Channel One TV. You understand?
This is Channel One TV, telling your story, empowering change.
Complete this rhyme. Twinkle, twinkle, little star.
How are you working? How?
Who's that?
Welcome to The Point of View.
Welcome to Face to Face on Channel One Television.
And hello, welcome to What the Papers Are Saying.
This be football made in Ghana. It be the only pidgin show where it day on your screen. Channel One TV.
Thank you so much.
Some people are late. You know, they have to catch up. City TV is now Channel One TV. You understand?
This is Channel One TV, telling your story, empowering change.
welcome back. Grateful that you stayed on with us. This is Channel One TV, and we're bringing you a live broadcast of that Supreme Court hearing on the application filed by the Speaker of Parliament, Alban Kingsford Sumana Bagbin, regarding his request for the Supreme Court to overturn its decision or ruling to stay the execution of the Speaker's ruling regarding the matter of vacancies in the House of Parliament. The process has started this morning with an objection raised by the Attorney General regarding 2 paragraphs in the Speaker's application, which he deemed scandalous, and of course the language in there not suitable or admissible in court. Then there was an objection by the lawyer for the Speaker as well, Thaddeus Sorry, regarding the presence or the involvement of Justice Jehu on the panel that is hearing the case. He sought to make the argument that the judge previously or in a previous life had political inclinations to the New Patriotic Party, and so was praying the court to either remove him or have him recuse himself from the matter. Subsequently, the panel went into conclave. That objection by Mr. Sorry was ruled out, and so he was asked to file his motion, which he did, and of course arguments on same application were heard. First from the applicant, Mr. Thaddeus, or the Speaker of Parliament, represented with legal representation by Mr. Thaddeus Sorry, and then we had Kwesi Abedu representing the majority leader, Afenyo Makin, and then there was the Attorney General, Godfred Yeboah-Dame, also making arguments there. Still in studio with me, my colleagues Hansen Ajiman and Fred Tete Jabano. Fred, let me start off with you. We've seen how it has played out in the Supreme Court up until this particular point. They've gone into conclave again, and so the expectation is that they'll come out with a ruling. But let's look at the arguments that were put forth by the various lawyers.
So we started with the applicant who moved his motion, Thaddeus Sorry, on behalf of the Speaker of Parliament. And as part of his argument, he indicated that he believed that the court did not have jurisdiction to actually hear that application brought before it to stay the decision of the court and the decision of the Speaker. He pointed out also to the fact that in this whole issue of the vacation of seats, they were of the strong belief that the Supreme Court did not hold jurisdiction, because when you look into the Constitution, Article 99, 1 of the Constitution, it states, gives you an indication as to how this process is done. It's sent to the High Court. So it is their belief that it is the High Court which holds the jurisdiction to be able to pronounce on the vacancy or not of a parliamentary seat.
So this is to challenge the original matter by Afenyo Makin?
Yes, but it is part of their argument for this particular application.
Right.
And the fact that the Supreme Court did not even have that jurisdiction to even hear the application to halt the decision of the Speaker. They felt like if the majority leader had any consent,
it should have been sent to the High Court.
They believe that it should be at the High Court and not at the Supreme Court.
Very well.
There were also concerns, like we raised initially, about the issue of natural justice, where the Thaddeus argued that it was only fair, per law and practice, that once you have brought a case which had an involvement of the Speaker needed to be heard. And the Speaker also needed to be given an opportunity to explain and defend himself. Once that did not take place, they are also of the belief that it went against that principle of natural justice. Hence, the court should really look at their decision and overturn it.
Right.
He raised concerns with the Hansard of Parliament. As part of the case of the majority leader in bringing a stay or getting an application to stay the proceedings or the ruling of the Speaker, he attached the Hansard of Parliament for the sitting in which the Speaker made the ruling directing the MPs to vacate their seats.
Right.
It is the argument of the Speaker in Parliament that that particular Hansard, which was attached as evidence to the case of the majority leader or to the application for stay by the majority leader, was not the official Hansard of Parliament, hence should not have been accepted by the panel which heard the case.
Okay.
So when you put all these into it, all they are saying is that, look, the court erred, the court did not have jurisdiction, the court used evidence which is not proper evidence in arriving at the decision to stay the ruling of the Speaker. And they are therefore calling on the court to relook at that and also overturn that old decision to stay the ruling.
Right.
That's what it's when it comes to the application or the argument by the applicant.
Right.
Yes.
Right. Abedu stood in for Afenyomark, and Hansen, what do you make of his arguments?
So, of course, they had gone to court and they got the favorable ruling from the Supreme Court, for which the lawyers of the Speaker of Parliament are currently opposing, and so it was expected that they will oppose it, and we heard him say that they vehemently oppose the application. He argued that they did not do anything wrong by going to the by going to the Supreme Court, and he makes the point that the Speaker of Parliament, by acknowledging that on Wednesday the processes had been filed on his office through his clerk, the Speaker should not have gone ahead to deliver the ruling in the first place. And
Right.
so essentially opposing to the extent that by coming to court by an ex parte application is not necessarily one that is in breach of natural justice, which is the right to be heard in any case, as this is a process that is allowed by the rules of court and by practice that the court uses. But issues of importance again to look at is the arguments that were raised by the Attorney General.
Right.
Now, I think for me, the Attorney General on the side spoke directly to the grounds for which the Speaker is thinking that the Supreme Court should overturn its ruling. And on the issue about the Supreme Court not having powers to stay actions of the
Speaker of Parliament.
The Attorney General argues that if you read the 1992 Constitution, the Supreme Court is given supervisory jurisdiction over lower adjudication bodies, which he seems to regard the Parliament and the Speaker of Parliament as these adjudicating bodies that the Supreme Court has powers to make pronouncements when their actions are in contravention of the 1992 Constitution. And so he refers to the famous case of Tufo versus the Attorney General, where he argues that even though the courts and the Constitution agree to the independence of Parliament, when the actions of Parliament or the actions of anybody who has been given certain powers by the Constitution go in contravention to the Constitution, then the Supreme Court is mandated by Article 2 and Article 130 of the 1992 Constitution to step in. Then on the issue of the process itself, Attorney General Godfrey Debordami makes the point that this is alien to the court practices. Earlier we had explained that when you go to the Supreme Court is the only court which has power to vary its decision. But the angle that you ought to go is to go for a review. And he's arguing that this review that the speaker, this action that has been brought by the Speaker of Parliament is not a review in the first place. It is a case of first instance on its own, asking the Supreme Court to quash its decision. So what it means is that it is not asking the Supreme Court to review its previous decision, but the Speaker has brought a fresh case, asking the Supreme Court to make certain orders that will cancel the orders they have made previously, but not necessarily to review them, which he believes that the sort of process applied by the Speaker and his lawyers is alien to the rules of court and the procedure of the Supreme Court. And we hear the Speaker's lawyer argue that it has been determined by the courts that when an issue is a nullity from the beginning, the plaintiff or the applicant has the discretion to choose any process whatsoever he or she wants to use for the court to address the case. And so, of course, the normal thing that ought to have been done, or the usual thing that ought to have been done, was for them to have filed for a review. And filing for a review is a different process, because then the bench of 5 cannot hear it. If it's a review, it will have to be +2, which will then become a bench of 7. They decided not to use that rules because, in their view, the Supreme Court, by giving that ruling, engaged in a nullity from the beginning, and so they were at liberty to use any process they deemed fit, and reason they used this particular process. Now, the Attorney General also goes further to look at the issues of the interpretative powers of the Supreme Court, and how all other powers are amenable to that interpretative power of the Supreme Court, and to say that no power really is above the Constitution. And so once that power has been exercised in a manner that is deemed to be against the Constitution, then the Supreme Court can step in. An interesting one also has to do with the secular. Mind you, we are saying that the Chief Justice on October 18, after the ruling, or even before the ruling, because we don't know the exact time, but on October 18, the very day the ruling to stay the Speaker's ruling came out, the Speaker had written to the Supreme Court rejecting the service of the substantive case itself. That is the case for interpretation. And the point the Speaker was making was that the service was done on Wednesday, which was done against a circular that was released by the Office of the Chief Justice. And because it was done again, it was not done on Monday, and we've already explained why that circular appeared to have settled on Monday, because of the dictates of Article 117. But the Attorney General explains that if you read Article 117, regardless of whatever circular that the Chief Justice might have given to Parliament, the most important thing is to look at the wording of Article 117 and what it means. If tomorrow Nana Akufo-Addo has a case with a member of Parliament, for Godfrey Adame, the most important thing is that if you are serving the court processes on that particular member of Parliament, are you serving it on him while he was on his way to Parliament, while he was attending to Parliament issues, or while he was his way from Parliament? If you are not serving that member of, or if you are serving that member of Parliament within that parameter, then you are in contravention of Article 117. But if you are serving that member of Parliament beyond that, and so if you are serving that member of Parliament at a time he was not going to do parliamentary business at the time he was not coming back from parliamentary business or attending parliamentary business, then it doesn't matter if you were attending, if you were serving the process on him on a Monday, on a Tuesday, on a Wednesday, even if a circular from the Chief Justice indicated that indeed you should serve members of Parliament, the Speaker and the Clerk processes on a Monday. The Chief Justice sought to clarify because she felt that it was important to clarify it because the circular was coming from her. But we didn't get much from her because she admitted that yes, there was an existing circular as far back as 2021, and when issues became rampant, she was called upon by the Speaker, and then she reviewed that particular circular, which prompted the circular we have now, for which the Speaker of Parliament is basing upon it to say that the service in the first place was wrong, and asked Godfrey Dami to comment on the import of the law, the
legal part of it.
And so Godfrey Dami's deduction essentially is to say that even if the Chief Justice had said serve processes on the Speaker, the Clerk and members of Parliament on Monday, it doesn't matter if you serve these persons on a Tuesday, provided you are serving it on them at a time when they are not coming from Parliament, at a time when they are not going to Parliament, or at a time when they are not attending at Parliament.
Quite interesting. We had the AG also cite articles 1.2 and then 2.1. If you can give us some education regarding that as well. Basically to say that any action any action or rules, procedures, orders of practices of Parliament that contradicts, are inconsistent with or purport to confer on Parliament powers not vested by the Constitution will be a sin against the Constitution.
Yeah, so I think this was in addressing the issue of where there was the argument where Parliament did not have, or the courts, the Supreme Court did not have jurisdiction over decisions taken in Parliament, and the rules and activities taking place in Parliament. What the AG sought to do using the two articles you have mentioned was to indicate that we lived in a constitutional democracy where the Constitution is paramount. Hence, whether Parliament, whatever body you are, whether Parliament, whether the executive, whoever you are, whatever body you are, or whatever arm of government you are, once you do something which is in contradiction to the Constitution, then the judiciary, which is the Supreme Court at this point, has the power to interpret and declare those actions null and void. Once you are doing anything which does not contravene the Constitution, the judiciary and the Supreme Court will not have any business in coming to engage or interfere in your business. But the moment you move away from the Constitution, the spirit, the word, the letter of the Constitution, and you go out of it, then the Supreme Court or the judiciary is called upon to give directions and declare those actions you have engaged in as null and void. So that is what the AG sought to do in citing those two articles and arguing his case.
Right, so in short, I mean, a provision in the Constitution is what the Supreme Court says it means, and not what any other body or institution declares it means.
So essentially, that's it. But and that would be for the substantive case. And if you listen to Godfrey Dami, essentially he talks about how even in this motion, it appears the grounds that have been stated by Speaker's lawyers include grounds that ought to have been stated in the substantive application, because it is out of that case that all these other legs are coming up. But I mean, if you look at Article 1(2) of the Constitution, it says the Constitution shall be the supreme law of Ghana. Any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void.
Right.
And so, Godfrey Bodami was basically saying that if you take Article 1.2 of the Constitution, it gives that supremacy to the Constitution of Ghana. Then Article 2 goes to say that a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment then the B says any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. Usually, this is read jointly with Article 130 because it is at Article 130 that the Supreme Court gets its original jurisdiction to interpret the Constitution and to also enforce the Constitution. And so, subject to the jurisdiction of the High Court and enforcement of fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement of or interpretation of this Constitution.
Right. And
all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament. So, for the purposes of this conversation, 130A is relevant here. And so, the Attorney General makes the argument that the combined reading of Article 2 and Article 130 goes to show that if you realize that something is being done and that particular thing is against the Constitution, or something is being done and we need an interpretation of that action to determine our way forward, the place you have to be is the Supreme Court. And so if Afenyawakin and the NPP think that the Speaker of Parliament, by taking a decision on Article 97.1, which talks about the vacancy of seats in Parliament, and using his own understanding of what he thinks Article 97.1 of the Constitution means, as an affront to the Constitution, and 97.1 needs an interpretation which, in their view, is different from the interpretation that the Speaker is putting to it, or the meaning the Speaker is putting to it. Then the right forum for the party to have gone to, that's the MPP MPs and their leader, Afenya Martin, to have gone to, is the Supreme Court. And so lawyers of the Speaker of Parliament cannot now say that they erred by going to the Supreme Court to seek an interpretation of this. The other angle to this is what Thaddeus Sori alluded to, is that again, if you read Article 99 of the Constitution, it talks about the proper forum to determine whether a vacancy has occurred. So Article 97 outlines the various incidents and scenarios under which you can say that a vacancy has occurred. And one is if the person is elected as Parliament, if there's a dissolution of Parliament. It goes all the way if somebody is expelled from Parliament. And then it comes to the G and H, which is of importance here, which is if the person leaves the party of which he was a member at the time of his election as Parliament to join another party or seeks to remain in Parliament as an independent candidate. And then the H deals with an independent candidate now joining a political party. The 99 deals with the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. And so there are those who are saying that if yes, the MPP side disagree with the Speaker making directives on whether these 4 MPs have vacated their seats, they ought not to have gone to the Supreme Court, but should have gone to the High Court. For the High Court, which has been given powers under Article 99 of the Constitution to make a determination as to whether there's vacancy. But the response that has been given to that again is that despite the fact that Article 99 gives the powers to the High Court to declare whether a seat has become vacant, which is for you to go to the High Court, the Supreme Court, in giving its ruling on the ex parte application by Alexander Afenyo-Markin, admitted that there were some interpretation questions that ought to be answered. Now, if you read the Constitution also talks about the fact that in an instance where a matter is before the High Court and that matter has interpretative angle, the High Court will have to stand that issue down and send the question of interpretation to the Supreme Court to be dealt with. And so those who have that school of thought are saying that even if the NPP MPs had gone to the High Court to get the High Court to declare that the seats of these 4 MPs are not vacant, as in that is what they seek to push, because there's the interpretative question, the High Court itself, even if seized with the question, may send the interpretation question to the Supreme Court for the Supreme Court to deal with it. And so there may not be anything wrong with the NPP MPs going straight forward to the Supreme Court to seek interpretation of the Constitution and to make a determination that yes, if we talk about somebody vacating, so what we are expecting the substantive case to deal with is what do we mean by somebody has vacated the seat. Currently we have 2 main issues, 2 main ideas floating around. The idea by the Speaker that immediately you come to Parliament on a ticket of the NPP, and in the next election you want to contest on the ticket of the NDC or as an independent candidate, then you vacate your seat in the current Parliament. Or the second one, which says it has to be an action that you've done in the current Parliament, i.e. I sit with the NDC, but decide that I'm no longer going to sit with the NDC.
Going to cross over to the NPP side.
I'm going to cross over to the NPP side, or I will sit in the middle and
as
be
an independent
candidate.
While still serving in the current Parliament.
While still serving in the current Parliament. So these are the issues that are floating around. I mean, the decision that was made by the Supreme Court in the ex parte application indicated that there is an interpretation question to answer. And so if you ask of my opinion, I'll say that if the question goes to the High Court, essentially the High Court may, because the plaintiffs will push that there's an interpretation. The plaintiffs may push that the Supreme Court will need to hear it.
And
but
if the High Court determines that indeed there's an interpretative question, then it will have to forward same to the Supreme Court.
Yes.
Right. So on the substantive matter of the possibility of the Supreme Court intervening in the work of Parliament, and just a few, things that I have picked up, and correct me if I don't get it right, is that there's no parliamentary supremacy. The 1992 Constitution remains supreme, and this same Constitution confers the power of interpretation on the Supreme Court. And so with the Supreme Court being the interpreter of the Constitution, a provision in the Constitution means exactly what the Supreme Court says it means.
It means what the Supreme Court says it means. I mean, any action that arises in court means what the court has come to a determination. And that is why when you come to our legal system, there's a hierarchy. And so we have the superior courts and then the lower courts. And so if a case even starts at the lower courts, which now most of them will be the district courts, if you disagree with the decision of the district court, you have the option of appealing to the High Court, to the Court of Appeal, to the Supreme Court, and even at the Supreme Court level, even go for a review of the decision of the Supreme Court. And so it is not only a matter of the interpretation of the Constitution, but no matter what issue the court is seized with, the angle or the finality of the matter rests on what the decision of the court is, regardless of what you believe it should be. So once the court has taken a decision, and that's why when the Supreme Court injuncted the Speaker's ruling, and some persons sought to say that the Speaker should insist on his independence and say that I won't listen to you. The argument was that if you don't agree, go back to them, because the system we've structured for ourselves is that the court should be the final arbiter of any dispute that arises, either between our individual selves or between yourself and the state, or even between companies, between anybody. It is the court that is supposed to make the final determination on any issue.
Fred, so therefore, I mean, it was the right move for the Speaker to file this application or to go back to the Supreme Court for a review of its own decision, if I can put it that way. Because he could have said, damn the consequences.
Yes.
I won't abide by your ruling.
Yes, he could have said that, but that would also go against the Constitution,
exactly,
the supremacy of our Constitution, which Hansen has explained very well. The Speaker had a choice to say, I won't do it. But
although he's bound by the Constitution.
It, but that comes with a lot of consequences. Consequences which amounts to treason.
Right.
Which amounts to treason. So the Speaker necessarily, if he wanted to overturn that decision, could not overturn that decision by himself. Then he needed to go back to the court to get the court to make a determination as to whether their decision still holds or it doesn't. That is why you would see that when Parliament returned, what the Speaker did was to avoid speaking on the matter, making a determination on the matter on the floor of the House, when they returned on the day after the Supreme Court, the Tuesday after the Supreme Court's decision. If the Speaker believed that he had the power to do that, I'm sure he would have made a pronouncement over there. But you see, this is a Speaker who is not just a Speaker of Parliament, but has practiced in the courts for a very long time. This is a Speaker who has been part of our Fourth Republican dispensation from the very beginning, who understands the law.
He's actually triggered processes for the removal of 2 MPs, I think, on similar premise.
Yes. He understands the law, and he's bound by the law. He knows that he's bound by the law and cannot, by his own means and power, just throw away a decision of a court. So then he calls his lawyers, he disagrees with the decision of the court, but also understands that it is the same court which would also make a decision or come out with a decision which you need to. So even though I disagree, the Constitution gives you an opportunity to go back, to get a review, to speak and explain yourself to the court, for the court to rethink its decision, whether it wants to agree with you or it doesn't want to agree with you. But all should fall under the rules of our laws, under the Constitution. It should be legal.
The point Fred makes is important on 2 levels for me. One, because if an issue had come up that the Speaker himself has been validly elected, the Constitution gives the powers to the High Court to make the determination, which of course is part of the court system. And so if the Speaker was to unilaterally say, I'm disobeying the orders of the court, then what happens if tomorrow an action had come up and there's a challenge as to whether somebody is actually a speaker, because the Article 99 we talk about, the 1B talks about the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a Speaker of Parliament or, having been so elected, has vacated the office of Speaker.
Right.
So any disrespect to, and I mean it is not only to the Speaker, it is to every Ghanaian, right? Any disrespect to the court, it's digging your own grave in the near future, because it may be somebody needing the court today, but you may need it most tomorrow. The second point is that we talked about the powers of the Supreme Court to determine if any action or act of Parliament is void. And based on that, the Constitution gives powers to the Supreme Court to make orders. Now, anybody who goes against such orders now commits a crime.
Okay.
So if you read Article 2, Article 2.2, the Supreme Court shall, for the purposes of declarations under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution, and shall, in the case of the President or the Vice President, constitute a ground for removal from office or under this Constitution. So, aside the President and the Vice, all of us fall under 2.5.
Okay.
A person convicted of a high crime under Clause 4 of this article shall A, be liable to imprisonment not exceeding 10 years without the option of a fine, and B, not be eligible for election or for appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment.
Right.
So not only is it a moral obligation to obey orders of the Supreme Court with respect to its interpretative powers. It is also a high crime, but of course in this instance the Supreme Court is yet to exercise its interpretative powers. But it all leads to that, right? And so if the Supreme Court had given an interpretation of a constitutional provision, and a person fails to go in accordance with that order made by the Supreme Court, there's an offense for which that person may go to prison for 10 years and may not be eligible for appointment or even election. But even though in this instance an interpretative order had not been given, the order that had been given, if anybody had sought to disobey it, may also lead to issues of contempt of court. And we've seen in instances in this country in proceedings where the court has exercised its contempt of court powers. In the 2012 election petition, we saw some persons going to prison because they were found on the wrong side of the contempt powers of the court. And so it's an important matter to put out there that the Speaker, being a lawyer, the Speaker having practiced parliamentary democracy in Ghana, at least more than all the other parliamentarians we have at this moment in the House, understood, one, the essence of going the right way in challenging the decision of the court, and two, the consequences of not doing so. And so it's very appropriate that they've gone back to court. At least they've had their day in court. It's been televised. We've all listened to them. The 5-member bench has gone into conclave and considering the arguments that have been raised. Pretty shortly, we should be hearing from them what their decision is. Do they agree with lawyers or the Speaker of Parliament that they should set aside their previous ruling on October 18, or they will quash or dismiss this plea that has come to them from lawyers of the Speaker of Parliament?
And even on a moral argument, you can't tell me that you derive your powers from the Constitution, and the powers which gives you the authority to perform your duties as Speaker tells you that you need to obey something. You need to obey the Supreme Court. And when it goes against you, you say, I don't obey it, or I disagree with it, I'm going to do my own thing. It even comes back to question the powers you are even having, where you derive those powers from, because it is the same Constitution which has given you those powers. So for the Speaker, outside even the legal aspect of it, he was bounded morally to obey the Constitution, which says that the Supreme Court or the court should be the final determinant of issues when you have problems. You understand? So for me, the Speaker was still bound legally and morally to follow the Constitution, and which he has done.
Right.
One interesting thing is, you know, in the October 18 ruling of the 4 MPs were supposed to have been allowed to enter Parliament. I was thinking that another test of how it was going to play out was if those 4 persons had actually made an attempt to have entered Parliament on the day the Speaker decided to adjourn the case indefinitely, because that was going to be an interesting one to have played out. But of course, from what we are getting,
but that would have put the Speaker in a very difficult position as to whether to call on the marshals to stop them, especially after the court had made a decision, and whether you are going to obey or disrespect or respect the decision of the court. The moment you use the marshals, you have disrespected the orders of the court. You understand? So for me, I think the Speaker on that day, I think
he handled
it well. Luckily, we didn't see these people enter into the chamber of Parliament. But they were in Parliament anyway. The Speaker's decision said you advocated your position as member of Parliament, meaning that you had no
you actually do not have
business
a chamber
to go into your office to go and sit there as a member of Parliament.
But I've wondered what would have happened if the Speaker's ruling had stayed, right? You know, there are a lot of conventions.
Yes.
So what we've been talking about has been the issue about whether somebody will sit at the left side of the Speaker or the right side of the Speaker. But we know in Parliament, the minority MPs are usually at the East Wing, and then the majority MPs are at the West Wing. So if that stayed, would we have now changed swap the offices?
But that's the duty of the Clerk of Parliament. So you would recall that even in the back and forth within about where people should be sitting, the majority leader indicated, Alex Afenyo-Mankin indicated that he questioned the Clerk of Parliament to ask whether he was the one who got the people to move to the other side by moving their name tags and everything. He said he didn't know about it. So I mean, if it gets to that point, the West Wing, the East Wing, the Clerk of Parliament,
and that's why some people are
based on the pronouncement of the Speaker. But see, what this thing has brought us in the last 2-3 years, in fact, this last 4 years has shown us as a country is that there are a lot of lacunas which need in our constitution. There are a lot of issues within our constitution we need to relook at. We need to bring our attention to. We need to address as a country. it comes back to the point. Are we going to call for an amendment of the Constitution? What are we going to do? Are we going to keep it? Are we going to just call for a replacement of it? These past 4 years has raised so much concerns. Even the death of Ekuya Donkor
certainly
has raised so much concerns about our laws and the details of how detailed our law is.
So there are, I think, so of course, constitutions are built on the experiences of people and looking at their present and gauging into the future and what it should look like for
changed.
the people.
The
and so
of today may not necessarily
it's interesting because you see, if, for instance, if you take the Ekuya Donkor matter, the constitution, if you look at it, clearly anticipates a situation when it happens to be a context in terms of a parliamentary election or a unit election. But in a funny way,
wasn't explicit on the presidential.
So in a funny way, it wasn't explicit on presidential, and it looked as
the
though
framers did not anticipate.
It looked as though the framers never anticipated that a presidential candidate would die going into an election. And I say this, and I say,
but that also people would raise concerns about that.
I say this because, of course, the relevant provisions that we've looked at, and even for starters, the Electoral Commission in a statement because I had spoken to officers within the commission the morning of the news, and they had indicated to me that, of course, the legal team was considering the situation and was going to come out with a release.
Right.
True to their words, a release came yesterday evening. And if you read the statement, it tells me that after the legal team of the EC considering the entire issue, they didn't come to a realization of any specific provision within the 1992 Constitution that deals with such a situation.
Just for clarity, I have that release here. I'll just read through it briefly, and then we can continue. It says, death of 2024 presidential candidate Madame Ekuya Donkor. Mind you, this release is dated 29th October 2024, and it reads, the Electoral Commission has today received information on the unfortunate passing of the presidential candidate of the Ghana Freedom Party, GFP, Madame Ekuya Donkor. May she rest in peace. While the 1992 Constitution and the Public Elections Regulations of 2020, CI 127, are not clear on processes to follow in the event of the death of a presidential candidate, Article 50, Clause 4 of the 1992 Constitution provides as follows, quote, where at the close of nominations but before the elections, one of the candidates dies, a further period of 10 days shall be allowed for nominations, end quote. The Commission has since informed the GFP to make arrangements to nominate a new candidate and inform the Commission accordingly. In the meantime, the Commission has suspended the printing of presidential ballot papers, which was near completion. Signed, Samuel Tete, Deputy Chairman, Operations. So, as you were saying, it looks like the EC is relying on Article 54.
But if you read that quote, they took part of 54
exactly
and left the other part. Of course, perhaps this may be a matter that will go to
even decided to forget 47.
Yes, yes, exactly. This may be a matter that will go to the Supreme Court, because if you read the entire code, they ended at allowing nominations for 10 days, but the continuation is, and where the death occurs at any time within 25 days before the election, the election in that constituency or unit shall be postponed for 21 days. And so, of course, the timeline that was given here, we are way about, today is 38 days to the election, and so we are not 25 days to the election. But the important thing is, when they refer to election, they refer to election in that constituency or in the unit.
And what is a constituency?
And what is a constituency?
In 47, Article 47 talks
Article
about
40.
there should be constituencies created in Ghana.
Okay.
You understand? So is Ghana a constituency as a whole? Can you look at Ghana as a constituency? And there are people who believe that yes, Ghana can be seen as a constituency of as a whole constituency because you have a returning officer being the what you call electoral commission chair. There are people who say no, you can't refer to Ghana as a single constituency. So like we said, our constitution has so many things which we need to relook at. Maybe the Supreme Court will now need to be speaking more and interpreting more, or we are going to sit down and say, okay, let's take this whole document and look at some amendments. Maybe we may need major amendments to our constitution or further clarity of what the constitution means. This 4 years, like I said before, has brought our attention to the fact that our country is growing. We are changing in culture. We are changing in the way we think. We are changing the way we do our things. And the constitution, as we always say, is a living document which needs to grow with us.
So
in growing with us, what do we do?
In growing with that, what exactly? What do we do?
In growing with us, what do we do? Are we going to look at it and amend it? Are we going to allow the Supreme Court to be given interpretations?
I mean, in this particular instance, for instance, if somebody is supposed to take it to the Supreme Court, and the beauty about ours is that you can even take a hypothetical situation to the Supreme Court and make it binding after they give their interpretation. What 54 means that if a presidential candidate dies, does 54 apply?
But does it explicitly mention presidential?
It doesn't explicitly mention presidential, neither does it mention parliamentary. But and so that's the point. And when Fred talks about some people saying you can look at the whole Ghana as a constituency, they go back to Article 47, which says no constituency shall fall within more than one region. So definitely Ghana cannot be a constituency.
It will be interesting to hear how this is argued out. If indeed a matter
exactly. And so then now it left to the Electoral Commission to use its own discretion on how to handle it. And I think that they might have acted properly, because there were those who believed that we should let it go. I mean, of course, may her soul rest in peace. She's died, but there's no need to restart the process. But then I asked the question, would that be our position and stance if it was to be one of the major political parties?
Right.
No, none of them would have, of having about over 80 million row, both parties having about 80% of the voter population. They won't agree that because the unfortunate happened, they shouldn't be part of the election.
Even as it is, there are concerns coming up that clearly she's no more and will not be able to participate. If the GFP fails to nominate a candidate, what happens to the ballot paper? Will the EC leave her picture on it? Will the EC remove her picture and the details? And if so, will the parties go into another balloting, or will they maintain their positions, or will it just be pushing up to close the gap?
This is
because mind you, the parties have already started campaigning or have campaigned over a period now based on their positions on the ballots.
This is one of the things that IPAC is supposed to address, because these are not clear constitutional issues, but are administrative issues. But of course, the administrative actions ought to be guided by constitutional provision. Now, if you read Article 50 from 1 to 4, you get the situation where that the Constitution wants to avoid a situation where somebody who does not want to be involved in an election but had started a process will not be involved in. And so if nominations are taken and two persons had been nominated and one person withdraws in the process, the commission is enjoined to open for nominations again. If somebody dies, the commission is enjoined to open nominations again. And so you cannot definitely put Ekuadonko's face on the ballot, because of course, what if by a certain action, of course elections are by numbers, what if people go and vote for that?
What if the dead one wins the election?
What if you put her face at number 3? She ends up becoming president. What do we do? So obviously there
are so many what ifs.
Yes. So the answer is that of course her face cannot be on the ballot paper. What I've heard the NDC argue is that in case a party decides not to present anything, you cannot do automatic rearrangement of
candidates,
of the numbers. Of course, so the NPP remains at 1, but you're pushing the NDC to 7. You're pushing Kwame Bediako to 11. You're pushing Alan Chamantin to 12. Or maybe those who may not affect their campaign strategy will be that of the NPP, which is and that of Alan Chamantin, which is still Asieho. But all the rest, Nana Kwame Bediako,
between 1 and
Nana Kwame Bediako says he's 12 disciples, 12 apostles, 12 pillars. Our very good friend Hassan Ayarga says he's number 9, he's the striker. NDC say they are 8, they are breaking the 8. So you cannot definitely do automatic. I mean, the good thing perhaps for us is if already the GFP have given an indication that they intend to replace Madam Ekuadonko. But again, with this conversation, the question that has come up is, when the Constitution says open nomination for a period of 10 days, what does it mean by open nominations for a period of 10 days? Does it mean open just for the person who is dead?
Or for other people to come?
Or for other people to come inside. Now, if you read the constitutional instrument, CI 127, Rule 17 talks about when somebody dies on the eve to the election. It talks about opening nomination and it limits it to political parties. So we get the understanding that when it is an independent candidate, because the person is not coming from a political, nobody is sponsoring him, so there's no need to go to anybody for that person to re-nominate. But are you opening for just that person, or are you opening 10 days for now everybody, and even those who were perhaps disqualified to come back into the frame? Exactly. But if you reopen nominations for 10 days, and so the point,
and this time fill everything correctly to avoid.
So then the number will go may go beyond 13. So the point Fred makes is important. The 8th Parliament, which is peculiar in its own self, a near-hang Parliament, has brought us to a point where we've had to encounter a lot of issues as far as our constitutional democracy is concerned. You remember the E-levy conversation and the conversation as to whether the first deputy or the second deputy can preside and vote. They had to take the Supreme Court to make a determination on the matter. And so now what we have on our hands is the issue of vacancy. And it's important that the Supreme Court, for me, I think that this is a good thing that the Supreme Court will listen to it, will make a determination for us to understand what it means. But even before we get there, we are in court today and we are waiting their decision. If until they take they give an interpretative order, these 4 MPs whose actions have actually resulted in this will end up to will have to remain in Parliament until a final determination of the matter is brought. But the important thing also is what is happening in the constituencies of these four people.
These four MPs.
In 2020, Formula was pretty interesting because Nana Akufo-Addo had been to the Formula constituency.
Yeah.
He had objected to the idea of
an independent
candidate. He thought that it was a disrespect. And then fast forward, he wins election, decides to play ball,
and becomes the most important man in the country at the time.
But okay, at the time, a lot of people think that he could have leveraged on that for something more, but I don't know what they mean by something more.
Or what he actually would describe as more.
But I mean, second deputy speaker is not.
There's no mean position.
It's not a mean position. It's an important position.
It's a
very important position.
But he himself, I mean, he he's going to go down in history as the only MP removed by 2 speakers. That is, if this ruling, if this ruling by the speaker stands.
But he has no problem with it. So
no, not at all. He's fine.
He's fine.
But the records will show that's what he is.
Exactly. I remember.
He's the reason we are here today.
He also moved by Speaker.
He's actually the reason. He's actually the reason why.
And he's now being removed by Speaker Bagbin.
This constitutional challenge, because it was a pronouncement on him in the last parliament, which has brought all these things back again. There's another pronouncement by another speaker in this parliament. This time he has 3 disciples following him. And now we find ourselves in the Supreme Court where we are looking for the court to make it clear what really the Constitution means by what has been stated within those particular articles attributing it. So yes, for good, for bad, he's contributed his quota to the growing of our country, to the growing of our democracy, to the growing of our constitution.
Right.
So for me, yes, we can say all we want to say about him. We can describe him the way we want to describe him. The luckiest man, the most powerful man, the troublemaker,
the unfortunate one.
He's contributing to the growth of our democracy. He's contributing to the growth of our laws, of our constitution. And we should give him some credit for that. What my challenge is in all this is how the politicians are playing out this whole legal matter. Everybody wants to play it to their advantage,
clearly.
In terms of politics and how it is affecting the governance of our country. For the last 2 weeks, our parliaments have not worked because our politicians have decided that they are going to play politics and litigate this matter in court. And whilst in court, there's no work taking place in parliament. One person says, I am majority. The other person says, you are not majority. One person says, the fact that I'm not majority, I'm not going to sit in the house to work until I reclaim my position as majority. The other person too is saying that, look, me, I'm come to become majority and be overturning certain laws and everything. In all these, it is the people of Ghana who suffer. It is you. It's me, Fred Jabano. It's an Atufo who suffer. Because the moment governance is not taking place, and we want to use legality and play politics with our legal issues, eventually we'll be the ones sitting home suffering. We'll be the ones having to pay things more expensive. Things will be the ones having to deal with things which could have been addressed easily by the House of Parliament so that life would go on and life would be easy for us. But here we sit today, even though it's interesting and it's good and it's helping the growth of our constitution, it's helping the growth of our country, it's also destroying us in terms of governance.
But was there any other way to have handled it? Because I mean, of course, we agree that it's politics, politics is strategy, and politics is numbers.
We could have challenged this issue in court and still got Parliament running.
How?
We could have challenged this issue in court.
Clearly.
We could we have no concerns challenging the issue.
Because here's the case: challenging it in court and having it run rests on the shoulders of the Speaker of Parliament.
Yes.
All right. Now, here's the case. We could see the Speaker attempting to avoid a situation where
he would have to make a declaration on the court ruling.
On the court ruling, where he may be disrespectful of the orders of the court, for which we've discussed here that he couldn't have allowed himself to do so.
But both sides.
So the safest option for
was
him
to go back
as
to
a
the
speaker
court. That is fine.
was to adjourn, go back to court. Of course, the majority side have triggered the constitutional provision that allows them to recall Parliament when Parliament is on recess or has been adjourned indefinitely.
Yes.
To deal with some important matters.
Yeah, Hansen, I get you, but I'm saying that, you see, we shouldn't even take out the speaker. The speaker is also a politician.
Yeah.
The speaker is a politician, a true and true politician. So from both sides, not just the minority or the majority, the speaker himself is part of the reasons why we are here. Nobody can tell me that the speaker is not also playing politics with all these things. Yes, the speaker is protecting himself by going to the court. But Hansen, let's take the first scenario. Would government business come to a halt when somebody is minority? No, I'm just asking. Would government business
take
come
out
to
the
a halt?
politics.
If we take out the politics. Secondly, what would hurt the speaker if he decides that I am going to obey the decision of the court and wait for
the determination,
the final determination of the matter? Do you get what I'm saying? In all these, underlining it is the politics.
It's the politics, clearly.
It's the politics.
I agree, but of course, what I make is that we run a very political system.
So we cannot take the politics out
so
of it.
to on one side admit that yes, ours is very political, and on another say that take the politics out is very
we are
problematic.
not asking the politics to be taken out.
Let's go back. Let's wind back to where it began. It began at a political rally.
Yeah, well,
it all began at a political rally, where the former minority leader Haruna Idrisu
actually the member for Prue West,
yes,
had raised this concern sometime with some members of the press. But it was escalated when the former minority leader Haruna Idrisu mentioned it on a political party rally platform.
And we know how the NDC, since the election in 2020, has insisted that they actually won parliamentary majority, but for certain accusations they made. Of course, some of which went to court, they were not able to substantiate. But it's evident out there that in their own way, they thought that they should have been the majority.
Yeah.
And we saw the initial brouhaha that emerged. And so when they saw another opportunity present itself, mind you, when Speaker Okoye had taken a decision that was largely influenced by the political stance of the president, right? Because Fomena would have gone as an independent candidate, and the NPP in the Ashanti region and in Fomena would have cried out or would have complained and still gone out in their election. But for the sort of attention the president himself gave to that activity, and the president at a certain point was very clear that he should be removed from parliament. And subsequent to that, processes were made. Of course, we know the likes of Oseche Mensah-Bonsu at the time had disagreed that was wrong. But I'm saying that underpinning it is the politics. And it's very difficult to say that let's entangle the politics out of it.
But where do we draw the line?
That is the system that we run.
You see, the issue is where do we draw the line? We cannot, I admit that we cannot take politics out of anything. You understand? But we need to get to a point as a country, as people who are involved in politics, whether directly or indirectly, to know where we want to draw the line between playing our politics
and where to put Ghana first.
Where to put our country first.
But see, when you talk about country first and interest, the question is, what is of interest to you is not of interest to another person. And you cannot tell me that there's a common ground of what is public interest. And I hear me here. The NDC say that if they get the majority, they can and they would revoke certain bills.
And in their own estimation, that is in the interest
of the general public. Of course, we know that there are other constitutional impediments that may not make it possible.
Exactly.
Right? But that goes beyond the work of Parliament. Right? The President assenting to a bill or not, that is
Parliament
not the thinking.
That is for
Parliament need not concern itself with that thinking.
Yeah.
And so they believe that they are fighting for the interests of Ghanaians.
But that also has its own political underpinnings.
Of course.
Because then there would be that populist approach that we said we would do, we have done it. But look at your president who would not sign it.
And the vice president who had said that when he comes he's going to revoke.
So you see, at the bottom of all this, it's the politics.
But the national, are you telling me that the idea of scrapping the bed tax by the NDC using their newfound majority is not in the national interest?
But will it feed into the political interest as well?
Yeah, of course. So when you say draw the line, we say draw the line because at this moment it suits us to say draw the line.
But you see, we are heading into a crucial election, and after the election, whoever wins will need a budget to run on until they are able to put their house together and come up with their own budget for the year. That hasn't been done yet. The vote of count has not even been done yet. And we have 38 days to the election. And you see, I think Parliament, the three arms of government, actually, the executive, the judiciary, the legislature, should be able to sit on this matter, get their act right.
I think the only solution going forward is the Supreme Court concluding on the matter as soon as possible. And it's important that we commend the current Chief Justice for sometimes making some of these cases available to the public to view. I mean, Fred has been reported from the court a long time before I joined. It's tedious reporting from the court because sometimes some judges do not even understand why they should allow you to type, and they expect you to write. And so, but with the posture with which the current Chief Justice is using in running the judiciary, from time to time, a lot of them are getting to understand because, I mean, all the LGBTQ cases across all levels, there've been an order to allow for the media to give live coverage to it. And so there's a case in the High Court on it. Any day the case is called, we can go to the High Court. And do a live broadcast. Recently, before the minority leaders issue was brought to a halt by the Court of Appeal, they had been given directives for live coverage of that as well.
This will be the ambulance case.
This will be the ambulance case. And so that aspect of it is important, but it needs to be handled expeditiously. We need to finish with it. At least if the 5-member panel is able to come up with its ruling today,
which they are going to do.
Today, it gives a headway that are the 4 MPs returning to Parliament when Parliament reconvenes? Are they not returning to Parliament when Parliament does not reconvene? Of course, as we always say, there's the option of a review for any of the other parties involved if they really want to take it to the next level. But essentially, our only way out now is for the Supreme Court to deal with these matters, conclude with them, so that we can have our Parliament in a form and manner that the Supreme Court and the Constitution envisage, taking into consideration the circumstances that we are faced with. But another angle of the conversation is what is happening in the constituencies currently.
Yeah.
I think the issue of Aguna West is one of interesting. Recently, there was a campaign launched by Madam Cynthia Morrison, and her team ended up walking through.
No, it was actually the team of the NPP parliamentary candidate, Chris Arthur. So Aguna West MP had finished with her float. The float culminated in a rally, but Chris Arthur was also on, I think, a door-to-door sort of campaign. They got to the intersection where Madame Morrison was having her rally, and I mean, the option was to drive through. So if you listen to the explanation by the head of research for the party in Aguna West, he says that the police had asked them to hold on. They were clearing a path for them. Which path was cleared? They were driving through when they started experiencing, I mean, these attacks on their vehicles and all that. Both parties have denied the shooting incident. That they blatantly denied it. I didn't come from either camp. This one says it's not from my camp. That one says it's not from my camp. So it is up to the police now to investigate and to determine who had that gun, who pulled the trigger, and where the person belongs to, if that will matter to the police in their investigations.
Perhaps it may not matter, but I'm sure if the person is identified, the people themselves
who know,
because these are very localized politics that they know each other.
Because among the accusations, I think they sought to mention one person and link him to one side that he spilled an alcoholic drink on one driver, and all that.
But would the court decision resolve this internal fighting within the constituencies?
Not necessarily.
It won't, but I'm only saying that it is also an interesting perspective to look at the tensions that are brewing in these constituencies.
Yes. I see that fuels the argument that if I decide to contest as an independent, even if I should lose my seats in parliament, do I forfeit my representation of the people?
So that's but the other thing,
because you see, until the end of the 8th parliament,
you are still a representative.
I'm still a representative of the people, voted by the people into parliament.
The argument that people make,
although on the ticket of a party,
the argument others make is that you were voted based on your membership of a particular party. And of course, if we understanding our political terrain, we know there are areas where you win not because of your personality necessarily, but because of your political party.
Largely.
And so, if you betray the trust of the people, the vehicle that brought you to parliament, then basically you are betraying the people
who voted for you.
And so you need not have any right whatsoever to still remain there.
But then that denies the people of representation until the 8th parliament comes to a close.
Particularly when we are 2 months to when we are 2 months to an election. But
the ruling for the stay.
Yes, if my decision to go independent,
deny the people representation.
But that also depends, because you remember in the Judge Chikwesen case, the court in Asen North, the court in giving its ruling on the injunction application, noted that when a certain affront of the constitution is alleged and that constitutional breach is proved, regardless of the consequences of say staying a particular person from acting, it cannot be higher than the consequence of breaching the constitution.
I think it's also a matter of determination, because you see, if I forfeit my candidature on the ticket of a party, does it necessarily deny me of my representation of the people in parliament?
This question, I say, is answered by the substantive suit, right? If the substantive suit determines that by deciding to now contest on the ticket of the NDC, having come to Parliament on the vehicle of the NPP, you have crossed carpet, and your continuous stay in Parliament is an affront to the Constitution. The Supreme Court, by the Jachikwesin case, is saying that we are who we are because of the Constitution. And so we cannot allow an illegality to persist just because we are talking about representation. Mind you, there are a set of people in this Parliament that have not been represented for the past 4 years. The people of the Guan constituency. In the past 4 years.
Guan,
the South.
South. Because Guan is Kofi Adams.
Yes, South.
So it's the people of South.
Kofi Adams is Buem.
But the Guan district.
So the new created district and
the Guan district.
And the constituency is the Guan.
Right.
The
Sancho Kofi,
the South people.
Lolobi.
Yes, these people for the past 4 years have been without any form of representation
for 4 years.
For 4 years. And so at least evidence suggests that representation is not an obstacle. The lack of representation is not an obstacle to holding the sanctity of the Constitution. And so if you are faced with two scenarios, the sanctity of the Constitution
will supersede,
and people not being represented, the sanctity of the Constitution will supersede that.
There are concerns also about the pronouncement of the court. At one point in time, the court says that, look, it's not good for somebody to be unrepresented in the House of Parliament. At the other point, the court says, look, whether you are represented or not, the Constitution, the sanctity of the Constitution should be respected. It brings into question then, what is the way forward?
No, but just before you continue, because in the other, there was evidence and proof of a breach.
Yes.
In this, there's yet to be a determination of a breach.
So these are two different scenarios.
There are two different scenarios. In the case of Jachikwesin, a competent court of jurisdiction, that is the High Court, had ruled that he was not properly nominated, and so his nomination all the way to his election and his swearing in was void, which was essentially affirmed by the Court of Appeal, be it procedural lapses or not, was affirmed by the Court of Appeal. The Supreme Court then made the argument that there's proof that the person who is there as MP is there in breach of the Constitution, right? But in this instance, there's yet to be a determination acknowledged by the court. There's yet to be a determination acknowledged by the court that there's a breach, because the court disagrees with the decision of the Speaker. Because if we can go through portions of the ruling of the court, so the plaintiff or applicant, so this is the ruling for stay of the Speaker's ruling.
Right.
The plaintiff or applicant has presented this present ex parte application for stay of execution of a ruling of the Speaker of Parliament declaring vacant the seats of 4 MPs and ordering the current members of Parliament to vacate their seats in Parliament on account of his declarations. We note from Exhibit B, the official report on the parliamentary debates on Thursday, 17th October, that Supreme Court that the bailiffs of Parliament of court had served the current action on him through the legal office. His objection to this proper service of a process from the Supreme Court was that it was not done on Monday. So applicant urges, and we appreciate that the said ruling will also likely to lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruption. Further, the subject matter of this suit raises real questions of constitutional interpretation and application and of the most fundamental and democratic rights of Ghanaians, being the right to be represented and heard in Parliament through their elected representative. If this impugned order and ruling, emphasis mine, is allowed to stand, it will render the grave issues raised in the substantive action negatory. So this is how the Supreme Court describes the order and ruling of the Supreme Court. So in this current instance, the Supreme Court does not believe that the order and the ruling given by the Speaker should be made to stand. And so they do not admit of a breach of the Constitution at this moment.
Right.
And that is why they raised the issue of representation ahead of the Speaker asking the four to vacate their seats. The point I'm making is that if in the near future the Supreme Court concludes the case, and if they come to a conclusion that this action by the four MPs amounts to a breach of the Constitution, I'm thinking that just like in the Jachikwesin case, even though the people will not be represented, they would agree that let us protect the sanctity of the Constitution than rather let people who are breaching the Constitution continue to represent the people. Yeah. On what grounds are you representing the people? Because the moment you continue to stay in Parliament, then you continue to degrade the Constitution, and we cannot come to terms as a people to allow such an action to continue. And so all these matters, I believe, will be settled when the Supreme Court finalize or brings a finality
the substantial
to them.
matter. Right, you're watching Channel 1 Television. This is our live coverage of the Supreme Court hearing of the application filed by Speaker Alban Bagbin to have the court rescind or overturn its decision staying the execution of a ruling given by the Speaker regarding the 4 vacancies in Parliament. These vacancies will be Aguna West, Amenfi Central, Suhum, and then Fomena. The court has gone into conclave. The panel is in conclave now. The expectation is that they will come out with a ruling. We will be here to bring you live what ruling it is that the court will be putting out. But we'll take a break here and return with more.
This year, I want to make my candidate with my one for the ballot. So, you go in the dream or what? You don't know, say every year they easily take the number 1 spot, give you a favorite candidate.
I just don't understand. I think I say easy get procedure where they take choose who go there the top. I said if we take give someone.
They take give them a favorite. So then they,
you sure?
You don't be an easy man.
If you have.
Yeah.
Okay, what bro?
Hey, my people. Why? You have some more questions?
Oh yes, boss man. We want to ask a question about the ballot paper positions.
They will discuss it. Why say if you cut the number 1 spot, you take give your favorite
candidate?
That's what people do. And you're fine. And you're fair.
Who?
You will, yes.
Oh yes.
Oh, my brother. Don't believe anything and everything that you hear around. Look, some of these political parties, they only get upset because they don't get what they wanted from the beginning.
Oh, okay.
Yes. Do you know that some of them, they even produce adverts and jingles even before the balloting is done? Not be wild anymore. But anyway, listen. Let me break it down for you. Listen, there will be 2 rounds of balloting. Look, in the first balloting, it is used to determine the order in which the presidential candidates or their representatives will be picking for the final ballot. And then the second round of balloting, that one is used to determine the position of the presidential candidate on the ballot paper. Do you understand?
Yes.
So if you pick number 1 in the first balloting, it means you will be the first one to pick a position in the final ballot. And then the number that you will pick in the final balloting, that is what determines where your presidential candidate will be on the ballot paper.
Okay.
So you know be fixed like that. Not at all.
Don't fix it.
Listen, the Electoral Commission does not have a favorite candidate and does not manipulate the processes to the advantage of any candidate. Not at all.
I just don't understand. So this number is choosing
all be lie.
Oh my brother,
All be lie. All be lie. We won't fall for these lies again. Never. Ghana for. Remember, the balloting process, it be finchim, it be transparent. All will be done in the full glare of the candidates, the party agents, and the media people self. Day to the day there. No secret for anywhere. No libi laba laba. A plain.
Imagine finding fufu and tilapia light soup in Nairobi of all places. Welcome to Mama Ashanti. Watch as Caleb dives into delicious flavors and rich conversations with the Ghanaian diaspora. Karibu Sana. Experience the heart of Ghanaian culture in Kenya only on Beyond Borders. Don't miss this exciting episode of Beyond Borders. This Wednesday at 7 p.m. only on Channel 1 TV. Beyond Borders is brought to you by Bethel Logistics, experts in shipping logistics.
We are Nyamia, we
Fachemi, Amonima.
Don't send any sessie.
Hey, I go father go yawo. One back to one hundred one.
Na nyame pe mpo na mo bon pa e chere na.
Enti sa nyame fufuru bi wo ha, obakoto wana sa futu.
They are the trailblazers, the pioneers, the unsung heroines who break barriers and set new standards.
Hello there, welcome to The Woman in You with me, Zoe Abubeiduado. Now, this is a show that celebrates the extraordinary resilience, strength, and leadership of women everywhere.
From the pioneers in enterprise, politics, and health, their stories are our stories.
I was very satisfied with doing something very little. But when my mother introduced the eggs and I started, it kept me so busy that I had to be there in the morning, afternoon, and evening.
I had been playing around with the different facets of it, and I realized, listen, I'm really onto something. I decided to formalize it, and I formalized it probably after, just navigating the space and doing different things and trying my hand at different things probably played around with it for like a good 5 years before I formalized it.
Be inspired, be empowered, be the woman you were born to be.
Join me, Zoe Abubeiduado, every week on Channel 1 TV as we celebrate these women who inspire, empower, and lead by example. It's time to celebrate the woman in you.
The Woman in You with Zoe airs Sundays at 6 p.m. only on Channel 1 TV.
After a busy day at work, consumed by the responsibilities of work, family, church, etc., it's great to get home to a detailed and comprehensive coverage of the day's biggest stories.
The Electoral Commission has disclosed that it will embark on a mop-up voter registration exercise.
Now let's take you to Circle where my colleague Philip Latte is. Now, hello Philip, what else can you tell us regarding the situation?
They've been able to salvage the situation, but they are still having their men here to control the situation.
The New Patriotic Party NPP running mate, Dr. Matthew Puku-Prempeh, has resigned as Energy Minister.
Residents of the Achimota-Kiseman area calling on the government to address the issue of malfunctioning street lighting.
Ensuring that all angles of the various news items are accurately and adequately covered.
The Chief Justice hasn't acted anything unconstitutional.
President Akufo-Addo must immediately halt his plans to make any further appointment to the superior courts.
Okisibi kwanu fa onu wa eye manhole enye kwan mbla won gbo on ikebule echa hunde mi ko mbutempo mabotemi
wo ebi we na me na ya school na abajo omo na ba ha wo ne ko bi ya school be na get pretty fee gani bi omo gba le ni wa pay pretty fee.
How you like that day go rain? We dey suffer for here, we dey push gas.
Government, I beg, can't do something for us.
The Channel 1 newsroom seeks to leave no stone unturned to bring viewers the best in news reportage.
Fred Duho reporting for Channel 1 News.
For Channel 1 News, Nashika Caesar.
Hansen Ajiman.
Akosia Otre.
Carver Stete, Channel 1 News. Gomo Trepo.
Mohammed Aminu M. Alabira reporting for Channel 1 News.
Reporting for Channel 1 News. My name is Kennedy Chumisi.
For CNR Business, my name is Daniel Sakiti.
Emmanuel Okon ni Lati for CNR Business.
Watch CNR for a comprehensive bulletin of the day's biggest stories at 8 p.m. every single day of the week, only on Channel 1 TV.
Imagine finding fufu and tilapia light soup in Nairobi of all places. Welcome to Mama Ashanti. Watch as Caleb dives into delicious flavors and rich conversations with the Ghanaian diaspora. Karibu Sana. Experience the heart of Ghanaian culture in Kenya only on Beyond Borders. Don't miss this exciting episode of Beyond Borders. This Wednesday at 7 p.m. only on Channel 1 TV. Beyond Borders is brought to you by Bethel Logistics, experts in shipping logistics.
What do you need from your leaders? And how can we build stronger constituencies?
Welcome to the constituency on Channel 1 Television. My name is Samuel Akom.
Every voice matters. Every story counts. Welcome to the constituency, the show that brings you closer to the heart of Ghana.
Market yawaha iswa inti market kesi waha.
Dining aduane na we say free no rich nampunda so leaves na dimpu go so tama school no ye bread.
Join us every Tuesday at 7 p.m. on Channel 1 TV as we explore the real issues facing our communities. From education and healthcare to jobs and infrastructure, we shine a light on the needs of the people.
Now it's obvious that Ghanaians will
complete this rhyme. Twinkle, twinkle, little star.
How are you working? How?
Who's that?
Our live broadcast of the Supreme Court hearing of that application filed by the Speaker of Parliament, Bagbin, asking the court to overturn its decision, staying the execution of the Speaker's ruling regarding that 4 vacant seats in the House. I'm in studio with my colleagues Hansen Ajiman and Fred Tete Jabano, and we're looking at the issues so far as it has transpired over the period, the genesis of the matter, where it has culminated to, and of course the processes or proceedings today. Today, when the court sat, objections were raised to the Speaker's petition which objections were raised by the Attorney General, Godfred Yeboah-Dame, regarding the language in the petition or application by the Speaker. He actually identified 2 paragraphs which he deems are scandalous and should be struck out of that application by the Speaker. The legal team of the Speaker, led by Thaddeus Sori, also raised objection with Justice Gewu sitting on that panel. And of course, the panel had to go into conclave, took a break, and came out with a decision regarding these objections. Subsequently, Thaddeus Sori was asked to move the motion. Motion was moved, arguments were heard from all 3 lawyers. That will be Thaddeus Sori for the Speaker, Abredu for Afenyo Makin, that's the majority leader, and of course Godfred Dame being the Attorney General and Minister for Justice. The panel has gone into conclave again, and the expectation is that they come out with a ruling regarding the application by the Speaker for the court to rescind this decision or to review its own ruling on the Speaker's ruling regarding these 4 vacant seats. Mind you, the matter is as a result of the declaration of 4 seats vacant in the House. We'll be joining the feed shortly and take you back to the Supreme Court to hear what the CJ and, of course, the panel of justices that sat for this particular hearing have decided on. We're just taking a few seconds to get everything in order for your viewing. But while we are at it, we want to say thank you to all of you who have joined us on YouTube. We've seen all the comments that you are sending in due course. We'll read them out to you. And of course, our viewers on X as well. I think we can go now to the Supreme Court to hear what the CJ is reading out as the ruling on this matter.
For appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment. From the above, it can be seen from the very first page of the 1992 Constitution that the most fundamental and hallowed right of every Ghanaian that the 1992 Constitution gives and jealously guards is that when anyone, including the President and Vice President, is embarking on an act, on any act that violates any provision of the Constitution, or if anyone is of the considered opinion that any law or rule enacted by any legislative body breaches the Constitution, that person can run to the Supreme Court for enforcement of the Constitution. That person does not even need to be directly affected by that act or law. This Supreme Court regularly exercises this original and exclusive jurisdiction for citizens of this country. Second, Article 130 provides, 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction and in A, all matters relating to the enforcement or interpretation of this Constitution. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or persons by law or under this Constitution. Where an issue that relates to matter or question referred to in clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with a correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Zanator Rollins, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution, and every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether a person has been validly elected as a member of Parliament, or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament, or a seat of a member of Parliament has become vacant, as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament, that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed, by reason of the meaning of Article 97(1)(g), to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in the suit. On the contrary,
We apologize for that, but that was the Chief Justice Gertrude Tokonu giving out the ruling regarding the application by the Speaker of Parliament, Alban Bagbin. We'll be working the lines to take you back to the Supreme Court so that we can all listen in to that ruling as delivered by the CJ. I don't know, but without prejudice.
Without prejudice. She's only setting the basis to make a determination.
Right.
We don't know where it will head. Because I've sat in court and listened to rulings and...
Right. Hansen, let's go back to the Supreme Court. We are back. Let's hear from the CJ.
In this house any longer, the house is accordingly informed, unquote. These are words that affect the rights of these MPs to remain in Parliament and the rights of their constituents to their representation. Thus, if a controversy is raised to the propriety of the interpretation of Article 97(1)(g) that led to this conclusion, then this court is rightly sized with jurisdiction to provide a hearing to the plaintiff. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97(1). A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if he is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. Or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker. Or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes of the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024 in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker, the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins High Courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Lord, we are extremely grateful. Ask the court, please, Ismail.
So, Mr.
We're also grateful.
So, Mr. Sorry, will you be filing anything? Or should we hear without you?
Oh, no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the Speaker on Monday. So he has 7 days. I will speak with him, draw his attention to the court's ruling. And then,
so it was served on him on, the order was served on him on Monday.
Last Monday.
Monday was 29th?
No, last Monday is the 20th.
Monday, just about 2 weeks ago.
No. It was served on the 20th.
On the 20th?
No, 21st. 21st. It was 21st.
So he's gone past the 7 days?
No, but if he's served with the order on that specific date, telling him to file within 7 days, it takes effect from the date of service. That is my understanding.
So he was supposed to file by 28th?
No, by the rules of the court, where the time limited for doing something is 7 days or less, weekends.
So he was supposed to file by when?
If you check out.
Today?
Yes.
This suit is adjourned to Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare.
Very well. Yes, I take it. That's really in your
so
own
if I would plead that because look at the time that we are closing and the fact that we've done some work, filing it by Friday is not possible. I also need to still go and take instructions. So maybe next week is fair. Today is Wednesday.
All right.
At least if I'll take 7 days to file the two.
No, do not count your 7 days from today. Your 7 days started running from 21st. You cannot make your own rules.
I'm just praying the court. I'm not making rules. I'm just praying the court.
So you will file by what date?
If he gives me instructions to file by the 6th That's just exactly the same. I'll try to be kind of more than as possible. It raises a lot of constitutional issues. Very properly assess the court if I'm instructed.
Very respectfully. There are 2 points that arise out of my left fresh, a brief submission to the court. And I made them. One, indeed, this is a matter for the interpretation of the Constitution. Respectfully, as I earlier submitted, the matter involving the interpretation of the Constitution, there's even no such party as a party who has an interest in the matter, apart from the entire state. Respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. So my submission is that
and the Constitution,
and the Constitution, yes.
In all constitutional actions, the Attorney General is required
to be the
defendant. To be a party.
Yes, to be a party. And respectfully, the point I make is that indeed the reluctance, with all respect, of the first defendant.
Can we get to know the objective?
Right. That first and foremost, if the first defendant is unwilling, with all respect, to file processes to enable the court complete the case by Friday, my submission is that the first defendant is not even a proper party to the proceedings before the court. And his absence will not derogate from the court's ability to proceed with the hearing of the matter. Because he, the first defendant, has no personal interest in the proceedings before the court. Indeed, it is even improper for the first defendant to have been joined to the action. The proper defendant should have been only the Attorney General. The second submission I make is actually linked with the first. Especially if a party who is a public officer is joined to a constitutional action involving the Attorney General, that party, if the court allows it, will have to procure services lawfully. My submission is that every counsel for the first defendant has not been lawfully procured. He has no lawful mandate to represent the first defendant. The procurement of all goods, works, and services in this republic must be in compliance with the Public Procurement Act. Section 14, subsection 1 requires the procurement of even the Attorney General, with all respect, even the Attorney General, when the Attorney General is procuring service of a lawyer, the procurement goes through PPA approval. Even the Attorney General, when procuring service of a lawyer to represent the country outside the Republic of Ghana in a high court in, say, London or New York, will have to be subject to PPA approval. My respectful submission is that the first defendant's counsel, I've tolerated him for no, and he's even seeking to use the fact that he doesn't have instructions of the speaker to continue as an excuse to delay proceedings. So I made the point that one, the joining of the speaker is not even proper to the action. He is not required to be a party whose failure to file proceedings should hold up the court. Number two, counsel for the first defendant has no lawful mandate to represent the Speaker of Parliament, because the Speaker of Parliament is subject to the provisions of the PPA Act, and indeed he must have procured the service of the PPA. He must have procured the service of the first defendant's counsel by the prior approval of the Public Procurement Authority. And therefore his representation of the first defendant is even unlawful, with all respect. Especially if indeed this is what will lead to a further or a continuation of a constitutional crisis which the nation is subjected to. And my respectful submission is that the first defendant should either be struck out as a defendant, and then also his counsel cannot even represent him because he doesn't have a lawful mandate to do so.
My Lord, with all due respect, it's not because some of the matters are not even. Well, it's
on the substantive suit to be taken by the substantive panel, which will sit in the next few minutes. The court will rise.
All rise.
Ruling regarding that application by the Speaker to have its earlier ruling that is staying the execution of the Speaker's order regarding the 4 seats rather that had been declared vacant. The Supreme Court has dismissed this particular application, but that will not be the end of the matter, will it?
Certainly, the substantive suit is there. In the ruling of the court read by the Chief Justice, she gave indication that it was the intention of the Supreme Court to make sure that the matter is dealt with expeditiously, and they were seeking to complete it by end of this week. We've had indication that indeed they may want to complete the case by this week. Some issues have come up with respect to the capacity of the Speaker to be sued because if you look at Article 88 of the 1992 Constitution, the Attorney General is the principal legal advisor of the state, and all actions for and against the state must be brought either in the name of the Attorney General or against the Attorney General. So the Attorney General is wondering on what basis the suit was brought against the Speaker of Parliament. Again, he also questions the capacity or the to represent the Speaker. He argues that even if the Speaker so wants to get an external solicitor, it has to go through the Public Procurement Authority, for which he seems to claim that the Public Procurement Authority had rejected a request for Thadio Sori to act as the external solicitor for the Parliament of Ghana, and so the Speaker should be one taken out of the case, and his lawyer again should be taken out of the case. The court is saying that this is a panel of 5 meant to deal with an interim issue. Every constitutional matter has to be dealt with at least a minimum of 7 judges, and so the court, as we speak, is not properly constituted for any matter relating to the substantive case.
Which will be the interpretation of the Constitution.
Which will be the interpretation of the Constitution. So if they are taking a brief recess, they'll come back properly constituted. They may be 7, they may be 9, but it has to be a minimum of 7. Properly constituted to now take decisions as to whether the Speaker of Parliament should be taken out as a respondent in this case, and the date of return as far as the case is concerned.
Right. So in fact, the CJ laid grounds to make a determination on the matter of the application of the Speaker. And it was quite clear how she picked the various issues raised in the application by the Speaker. I mean, if you can just take a look at
so what the CJ did was to basically put this thing in 3 ways, 3 issues: jurisdiction, service, and the natural justice.
Right.
So in addressing and ruling on this particular application, she put it in these 3 different categories and dealt with it specifically on jurisdiction, the service, and the natural justice. She started with the jurisdiction and indicated, the applicants had argued that the Supreme Court did not have the jurisdiction to hear this particular matter. It was not clothed with the proper jurisdiction, and they were wondering which process or which of the rules allowed for the Supreme Court to hear a matter like this. But the judges, after going into chambers and coming up with a ruling, indicated and mentioned Article 130 and Article 2 of the Constitution. Article 2 of the Constitution, which deals with enforcement, and then Article 130, which deals with the original jurisdiction of the court. In the belief and understanding of the court, they had the jurisdiction. How did they get the jurisdiction? The court explains that, one, the moment an issue of interpretation was raised, it clothed them with the jurisdiction to hear the matter. They went to address the issue of Article 50, which talked about a high court declaring, having the powers 99. To declare, Article 99, which talked about the high court having the powers to declare a seat vacant, and indicate that even in the process of declaring a seat vacant, the moment a question of interpretation arises, it needs to be brought back to the Supreme Court. And this time round, the question for interpretation has to do with Article 97G of the Constitution. Yeah. Once it arose, the people, which is the applicants for, or the applicants for the first writ, which is Alex Afenyo-Makin, had every right to come with to the Supreme Court for interpretation, which that's the issue addressing the jurisdiction. For service. The people, the speaker and his lawyers had argued that he was not served properly because there was an agreement between the speaker and the judiciary led by the Chief Justice, and the circular later indicating that the speaker had to be served on Mondays per the circular. The judges, in their understanding and their wisdom, said, look, a circular on an administrative action does not overshadow or cannot supersede the Constitution and law. And per the law, you can be served at any day, any time, once he has served properly. The administrative action was just there to resolve a particular issue which the judiciary had with the legislature. But even with the administrative action, there was a part of that administrative action which says that it was the speaker who could be served in person on Monday. But then his office, I mean, you could serve the speaker through his office. The legal office, on any day.
Other day.
The last part had to do with the issue of natural justice. The argument was that they were not given a hearing when the majority leader came to put a stay on it. And the court is of the belief that you did not need to be given a hearing. All it was that we needed to look for exceptional circumstances to allow for an ex-party hearing. And the exceptional circumstances were that the people of these constituencies were not going to get representation, the MPs were going to be affected. So those were the exceptional circumstances in which the court looked at and allowed the ex-party to take place. So in all, they decided that, look, we're going to dismiss this application. So as we stand now, the stay still continues.
All right. Thank you very much, Fretete Jabano, Head of Current Affairs here at Channel 1 TV, City 97.3 FM, and of course, Hansen Ajiman, our court correspondent. Thank you to all of you for joining us on our live coverage of the hearing by the Supreme Court on the Speaker's application to review or to change its ruling that stays the execution of the Speaker's ruling regarding the 4 seats. That application has been dismissed by the Supreme Court. Thank you to those of you that joined us via YouTube, and of course a big thank you to all of you that joined us via X, formerly known as Twitter. My name is Nanatufo Boateng. We'll definitely be bringing you updates in our subsequent bulletins and of course programs here on Channel 1 Television. Don't change that dial.